Khoza, have we reached some sort of conclusion on 311?
I have discussed with Advocate Vanara, and I given him my own submission, and we are going to consolidate that, and he's going to put it together.
Together with what Honorable Waters had put together?
No, not necessarily.
Okay.
Honorable Waters did give me something as well in respect of 3.1.1, and I've included that in the submission I've made to Advocate Vanara.
All right. Can we then postpone that one just for a little bit later, just to make sure that you guys have coordinated everything? We'll come back to it, although we made an undertaking, we'll start with it. Or do we want to take both versions, Vanara? And I'm assuming that you're just doing the wordsmithing, because it should be a members. Honorable Waters, you understand? Okay. Could we do that? Could you just email it, look at the two of them, and then we will come back to it before end of business today if you have reached some sorts of consensus. Otherwise, we'll put out the two versions and we can think about it overnight. We don't have to finalize anything tonight. At least we'll have those and people can work on them. Are you ready for yours, ma'am? Yes, ma'am.
Thanks, Chair. I've put together the different sections which apply to the duties, responsibilities of a board, as well as what happens when they don't fulfill those duties. I don't know if we should agree about what those sections are, because it's going to be very important when we come to recommendations. I don't know if I can speak to it quickly. So for the Broadcasting Act...
Just hold on. At that point, because members will have to at least have sight of it unless they're prepared to write. I thought, and I'm looking at the capacity here, is it possible for us to get that and maybe just print it so that when Madam Van Dam speaks to it, we have something in writing, the same Vanara, and we'll revisit those two as the last two for now, and we'll add to those just before we go. What we're saying is whatever we give tasks for to now, people will talk to them before we leave as the last few items, and then members can go and agree if we are not together. Is that okay? Thank you so much. So 311 then, and I forget which one your one was, Ms. Van Dam. Which point was that?
It's 3112, but 311 also, but relating to the fiduciary duties of the board. So just detailing what legislation we're basing our analysis of the evidence,
okay.
And then later our recommendations.
So both of them are for 311?
Yeah.
All right, it's fine. So if somebody can just make a note that before we adjourn, we will revisit 311 with both both extracts or suggestions from members. I just want to get a sense. In terms of timing, because we mustn't lose sight of timing. I mean, I think we are on page 7 of page 26, and those are just the factual matters. So if members can be cognizant of that, but we will not unduly rush. If it means we must add extra hours tomorrow, we will do that, but just remind members that we are on page 7 of page 26 of the stuff that we thought would go much easier or much quicker. Can we then move to 312 on page 7? Honorable Waters.
Chair, on the 4th line, where it says, and those who are seemingly pursuing their own agenda, I think we should include their own and political agendas. There were some political agendas that were at play, which was evident from the evidence that we were given during the hearings. So I think we need to put in their political agenda as well. And on the next line, where it says not necessarily in the public broadcaster's best interest, we should put there the public broadcasters or the public's best interests. Or the public's best interests. And then The last sentence, which starts with intent on achieving certain outcomes, I think that it's irrelevant and could be removed to clean up the paragraph.
From all former members.
Okay. All right, there's a proposal that you're saying we take it out of here totally and we take it to observations. That's the proposal. All right, we'll come back and try and just note the proposals that are there. Ms. Khoza?
Chair, Honorable Waters has pointed out that we should include the political agendas because I do think it was mainly one's own agenda. I don't know though, maybe he may elaborate on that, I'm not so sure.
All right, we will try and get closer together. So you're just talking about the inclusion of political agendas. And then we'll come back to all of them. Mr. Swart?
No, Chair, I was just saying that where we say own agenda, one could rather say their personal or political agenda. I think that would cover both of them, personal or political. So it's not a focus on either one of those. And I think, Chair, this is actually, we're dealing with testimony here under 3.11, 3.12. This is actual, what we are saying is testimony, so it's not quite observations. Observations will arise from the testimony. Yes. So we actually are, maybe this should stay here at this stage. But I agree that that last sentence is not necessary. Thank you, Chair.
Yeah.
All right. Consensus that we will say pursuing their personal or political agendas, then it covers both. And we say in the broadcasters of public interest. Happy with that? Yeah. And then we take out the last sentence. With those amendments, can we move to 411?
Chair?
Sorry, is it still 312? Mr. Motsoeneng? 312 still?
No, I wanted to add 313.
It's fine, you can, let's first just ascertain if 312 has been dealt with.
Okay.
It has been dealt with, let's add 313, then you can carry on. No, 312, we're now happy. You could add your one, sir.
No, because I thought since we're talking about the fiduciary duties of the board, there was a lot of tampering with their responsibilities in terms of the MOI and the delegation of authority framework. And I think it must be, I know that we kind of touch on it in the next section, I think, but this might be a nice preamble. It directly affected their thing. So I drafted a thing which we can discuss, which says that testimony suggested that the minister was at this.
As you read it, please read it slowly so members can internalize it. Yeah?
Okay. Testimony suggested that the minister was at the center of hiring and firing of board members, curtailing the functions and responsibilities of the board through alterations of the memorandum of incorporation documents, which had a rather confusing effect on the delegation of authority framework and contravened the Broadcast Act. Testimony suggested that the minister was at the center of hiring and firing of board members, curtailing the functions and responsibilities of the board through alterations of the memorandum of incorporation documents, which had a rather confusing effect on the delegation of authority framework and contravened the Broadcasting Act.
Okay, excuse me. That is the sentiment. I mean, we can do the words, whether it's curtailing or encroaching or whatever. Yeah. But we understand the sentiment that Honorable Motsoeneng is trying to add there. So can we talk to that addition? Yes, sir.
Chair, I see that does come under paragraph 5, political interference, and 5.1.3, testimony from the witnesses, that in many instances the Broadcasting Act was disregarded. So maybe it might be a better place to put it under there, that clause. I'm in agreement there, because it speaks to And then the next issue is about memorandum of incorporation. So I agree with the sentiment, but just where to put it.
Yes, sir.
You know, the reason why I said I know that it's mentioned in it is because I don't mind it being repeated, because this, I think, speaks to a slightly different issue. Because the documentation, that delegation of authority framework and the memorandum of incorporation were quite specific about the duties of the board and their responsibilities. And I think this sort of says the same thing. I did sort of put it here as an alternate place to put that preamble that I was talking about earlier on. But I think both are relevant in both places.
All right. No, I not let me say what I think. Let me try and interpret what Honorable Motsoeneng is saying, that it is not necessarily only under one heading, because remember we were trying to deal with them under headings. It could be applicable both in the shareholders' behavior and in the board's behavior, or lack of behavior in both instances. I think that's what Motsoeneng is saying. And if that's what he's saying it wouldn't be harmful if we had them under both headings. I think that's what Honorable Motsoeneng is saying. So can members talk to that? First of all, do we think that it is an accurate reflection of the testimony delivered? And then we can argue whether it belongs to one or the other. But right now, remember, we're trying to reflect without making observations. We're just trying to reflect what testimony brought forward at this point. Not saying it's our opinion or we agree or disagree. That's.
Suggest we just put it in as a draft where Honourable Motsoeneng suggests, and we can come back to it and look at it. No, well, yeah.
So the suggestion is we put it in both. When we come back to adopt, we can decide if it's feasible or if it's one or the other or if it's neither of them. Is that okay? All right. You want to say something, Honourable? Is that fine? All right. We will then put it as 313 for purposes of the 24th. And when we get to 513, if it's still relevant there, it's there. But remember, this is but part of deliberations. We'll still clean it up tomorrow and eventually on the 24th. So 313 we'll add. Agreed. We'll wordsmith it and you put this, yeah. We'll wordsmith it and it will be presented in a document before formal adoption. Can we then move to 4.11? Honourable Swarts.
Okay, I've had a lot of thought about this, and it's particular goes to the heart of the conflict between the Company Act and the Broadcasting Act. And I think we need to, I've had a discussion with the law advisors as well, we need to set out in greater detail the conflict between the two and the provisions, because here we're going straight into the Articles of Association and the MOI, and we start with applicable legislation. Then we start with a very broad legal concept which doesn't actually define the problem. The problem is the application, which applies. We know, in our view, which applies. So maybe the law advisors can also just speak to us. And we spoke over lunchtime. They were already preparing a draft on setting this out, the conflict between the two laws, how it is resolved, and that leads in to the next section, which is separation of powers, political interference, and the trumping of the Broadcasting Act. I think it's these 2 pages that we can consider together. But my concern is, and maybe I should have raised it earlier, we need to set out the regulatory framework that governs the whole issue. And that is the Companies Act, the Broadcasting Act, as well as the ICASA Act, because they gave evidence. So maybe this is our first bite. When we come back, we might have to rephrase and put right at the beginning the regulatory framework. This is the laws that apply. And then we set out the fiduciary duties, we set out the conflict. Because in certain circumstances, you want the Companies Act to apply, such as fiduciary duties. But when it comes to the nub of the firing of board members, that's the crux where the Broadcasting Act, in our view, applies. But we know the minister holds a different view. And that was elicited at the Communications Portfolio Committee last year, where she said the Companies Act trumps the Broadcasting Act, notwithstanding the legal opinion that was given by the parliamentary law advisors. So I would suggest 4.1.1 needs to be redrafted. This whole 4.1 to 4.1.3 can be very easily drafted by the legal advisors, setting out the conflict of laws, because it also then pertains, and then after that, you have how that applies to the Articles of Association and the Memorandum of Incorporation.
All right, I'm just thinking aloud, and I'm allowed to participate, am I not? Yes, I'm just thinking aloud in terms of, remember we're trying to capture what actually was given to us in terms of testimony in this chapter. Not observation or recommendations. Now what we're putting there, I'm not sure would fit snugly under testimony. I agree that it has to be there somewhere, but I'm not sure that it should be under testimony, because nobody came to testify in terms of legislation and which one should apply. Nobody came to, none of the witnesses testified. I think what you're saying makes perfect sense, but we would have to, somebody must draft it for us, and there's no problem. And we can, in Part B, Cindy saying to me, I don't even know what Part B is, but we can find the more proper space to put it in. Can we agree on that one? So go ahead and draft it for us. We will first of all agree that the draft is accurate and then decide in which section it fits. Is that all right?
Yeah, I agree, but if you look at 4.1.1 and 4.1.3, that is not testimony. That is setting out legal principles. So I think your point is correct.
That's the point that I'm making.
So it might be suited to put it in somewhere else, right at the beginning, where we set out the regulatory framework. Then the evidence that came out about the conflict, the Memorandum of Association, then it's correct. Yeah.
And of course, it will have effect on the numbering. But can we agree, for sake of progress, that 4.11 to 4.13, no, up to 4.22, the whole of 4, we will redraft, do what Mr. Honorable Swartz is saying, and we'll find the relevant spot to put it in. Is that okay? Let's take Van Dam and then take Kwankwa, under Kwankwa, I beg your pardon, Mokoena, Kubisi, and then Loliwe.
Chair, I've got a different view on this. Now, in terms of the legal principle mentioned in this paragraph, lex specialis derogata, if there's conflicts between laws, the one that is more specific applies. So in terms of the SABC, the Broadcasting Act is the primary act. And then if there is sections that the Broadcasting Act doesn't deal with, then we can look at the PFMA or we can look at the Companies Act. Now, the way this subject is put in the document, it makes it seem like it's a matter that isn't actually clear. But it's really quite clear. The Broadcasting Act trumps the Companies Act when it comes to the SABC. So I don't think it should be couched as a matter that isn't very clear. And then also I'm a bit wary of including the Memorandum of Incorporation under legislation. It is a document that's under contestation, and I'm wary of us as a committee relying on that, on its contents, because we're not even sure whether the manner in which it was approved is correct. So when we are considering this document, we should rely on the laws that were approved by the National Assembly, which are the Broadcasting Act, the PFMA, and the Companies Act. The MOI, under contestation, we cannot rely on it.
All right, it will be Mokoena, it will be Loliwe. Had I known to? No. Okay. So just let's rewrite Mokoena, Loliwe, Khoza, Kubisa, and then Waters. On this matter, where should it be? Should it be there at all? All those times. It's open season for 4.1 and 4.2. Let's start with Mokoena.
Yeah, I'm strongly of the opinion that it shouldn't be here. I think because we're dealing with evidence, we must exhaust the issue of evidence, and there's no evidence on this issue. I do, however, think that under observation, we must have a section that deals with regulatory framework, right? And in that regulatory framework section, we then deal with all the issues pertaining to our opinion on the Broadcast Act and how it was applied by the board and so on and so forth, the MOI and the contradictions and the issues that we're dealing with there. All those regulatory issues must then be dealt with under our observation because we don't have evidence on it. But I think as Parliament, we must give a legal opinion from our perspective.
All right, so you're suggesting that it's relevant. I'm saying to state it, but it's not for this chapter. All right.
I'm suggesting that under observations, under our observations, we must have a section of regulatory framework.
All right. Loliwe?
Thanks, Chair. Chair, I was to support the initial proposal that the redraft of the whole of 4.2, it should not come back here, but rather go to observations where you will say, this is what transpired in the testimony, and it is against what is law. I also agree with Honorable Van Dam. We should not be doubting what is law. Our legal advisors should come out clean to say this is what was happening, though this is what is law. Once we give an impression that we are not sure of what law is, then it means it's going to deal with the credibility of our report. Let's be decisive there, Chair. Thank you.
Chair, I want to keep my promise. I want to stick to what we agreed on during lunchtime. Chair, I agree with the previous speakers. I really do think that, consistent with Van Dam and Loliwe, that the memorandum of incorporation shouldn't be under legislation. And again, it's a document in dispute because we have about 3 versions, if you remember. Thank you, Chair.
Chair, I'm of the strongest view that this matter should go to the observations, not here, because it should not appear that we are doubting the legislation that is there, but we can put it under observations.
Chair, I want to agree. We've put legislation up front. The principal act is the Broadcasting Act, no other act. Where it's silent, you fall back on the Companies Act and the PFMA. As far as the MORs are concerned, it is evidence and that must remain here. As far as I'm concerned, it should stay under Section 4 as evidence. It shouldn't be moved to the front. Because it's dispute.
Explain this particular.
4.2.2. It says during its evidence gathering, the ad hoc committee received three MORs. So it's evidence that we got, right? Okay. One undated and unsigned. A second one dated the 20th. I won't read the whole paragraph, but you get the gist. That is evidence, and that must remain here.
No, absolutely correct. Again, it's one of those that it doesn't detract from the report if we have it in 2 different sections, because it applies. Yes, sir.
We did have evidence from Minister Mutambi on the relationship between the Broadcast Act and the Companies Act. Does it reflect in that evidence? Because that evidence is going to be crucial, because it's the principle that then guided the minister in terms of this alterations of the MOI and so on and so forth.
Oh, you're absolutely right. We were saying that it was not evidence. In fact, it was evidence. All of this, at some point, somebody spoke to it. Whether it was the MOI, whether it was the Company Act. So let's agree that it will appear in evidence. We will tighten it up, Honorable Swartz, as you have suggested. We will then ask the legal team to word it better. And it's one of those that we will come back to, even if it's tomorrow. So if you guys could propose rejigging 4.1, 4.2, and Honorable Swartz will then present it tomorrow. Because at the end of the day, this is a political document. So, Swartz, that's your responsibility to make sure that at some point tomorrow, you will come and make suggestions on 4.1 and 4.2. Whether it becomes one point or 2 points is not relevant, but you will come back and talk to us, and it will remain under evidence. Closing it, Mr. Motsoeneng, sir.
On the same point, while we're talking about regulatory framework, there was also a confusion or perceived confusion around the issue of the public protector's remedial actions, whether they're binding or not. I'm not sure if we should put that under the same subject to say that our observation was that, am I making sense so far? So that we say that our observation, so that we say that our observation was that the SABC and the minister made wrong decisions based on a wrong assumption that the public protector's report remedial actions are not binding. If I'm still making sense.
Yeah, I know you're still making sense, but I just want to refer you, sir, to page 23 and 24, because that's what we were trying to talk to. I know we might not have dealt with that item there, but we have a whole chapter around the responses of the public protectors when governance and ethics fail. So couldn't we smuggle it in there somewhere? Or do you want it up front? No, we won't smuggle it, we'll put it. Yeah, okay. So can you just, on your document, make a note so that when we get there, you can raise it again? Thank you so much. Could we then move to page 9, separation of powers? Can we try, I'm so wary of pushing members, but can we just try to speed it up slightly? Otherwise, we'll be here until midnight, which I don't have a problem with. Separation of powers, 511. Honourable Waters, anybody else after Waters? Waters at this point, yes, sir.
Chair, with regards to the general principles of separation of powers, I think it's important that we stipulate which legislation dictates that. Right? So, and I won't read it all out, but I'll refer to them because you've asked us to be brief. So we have the Constitution, which stipulates the separation of powers. We have the Executive Ethics Code, which does the same in certain sections, the whole of Section 2. I can read out the sections 91, 92, and 96 of the Constitution, the Executive Ethics Code, the whole of Section 2, and the power, privileges, and immunities of Parliament and Provincial Legislators Act. There as well, Sections 13, 17, the whole of 17, quite clearly stipulate the conduct of what's expected of a minister and the separation thereof. And I think that needs to be placed right at the beginning of this particular chapter, so that when people read it in a few years' time, they're looking over it, they can actually see what was expected of the minister in this regard. Thanks.
I don't want us to rewrite the Constitution, rewrite the PFMA, and so on. And the other side of the coin is if we just say Chapter 1 of the Constitution or Chapter 1 of the PFMA, somebody would argue that they might not have those documents readily available. So I'm just trying to do a balancing act. Do we write up front, copy and paste those sections you're talking about, or do we just make one sentence and says the separations of powers is informed by A, B, C, D, E, F? Or do we say the separation of powers is informed by, and we list them? I'm trying to get that thing. My own sense is that we should refer to the relevant legislation or constitution. I really don't think that if we're going to go and take what is in the Constitution and put it in this document, or take what's in PFMA and put it in this document, that is realistic. But it's just my point. And I know people are going to say that for prosperity, maybe we should put it. But the other side of the coin is for prosperity, people must go and learn the Constitution. So I'm just putting that because I'm afraid that this document will have so many extracts from the relevant, whether it's the Public Broadcasting Act, whether it is the Constitution, and ours should be saying this is what informed us. I don't know. I'm just saying as you discuss, think about those things. But Honourable Waters is saying, in essence, that somewhere we must refer to that talks to the separation of powers from a principal point or from a constitutional legislative point of view. That's what he's saying. The question is the form in which we do it. Can people talk to that? The form and the positioning in our document. Can we take Khoza and then Mokoena?
Chair, my view is that 5.1.1 is okay where it is. I think it's actually good. And I do think that it captures the essence of what the Constitution envisages. And I think the points that Honourable Waters is coming up with are points that may be we may factor them probably in during observations or something like that. But here, because we're talking about the political interference, we need to set the tone for what will follow after that. So I am happy with 5.1.1 to be where it is, and I think it captures what we are intending to get at.
Yeah, no, I think the heading separation of powers might be confusing. And I think I think we must take it out because separation of powers will then deal with organs of state. And here we're dealing with
No.
eh?
No, carry on.
Yeah, because it talks about organs of state. It talks about the judiciary and whereas in this case we're dealing with an executive issue where the executive must exercise oversight over a state-owned entity. So my feeling is that, because then if we say separation of powers, we then have to explain it from a constitutional perspective and how it applies to this SABC issue. And I don't think it does in this particular case. So my suggestion would be that we leave it as political interference and leave out separation of powers.
If you go to 4.1.5, we actually talk about at 5.1.4.
Yeah.
We actually talk about the removal and appointment.
Yeah.
So that talks to different organs of state,
And separation.
and
of
which
powers.
is a separation of powers matter. So I'm trying to argue against what Mokoena is saying, that
Yeah.
it shouldn't be separated. This is not political interference. This is, does Parliament have a right and did it play its role in the appointment or the removal? If you capture 4.1.5. So
No, Chair.
we've got separation of powers and we've got political interference. Maybe it's the heading that's wrong, but I think the context that we are saying here is correct. Maybe, I don't know, but let's take Loliwe. No, let's take Nkwankwa first because I had noted him, and then Loliwe.
Thank you, Chair. I think Honourable Walters was right at the beginning when he said we don't need to refer, as we are saying, to specific sections of the laws, right, that deal with these matters, sections, but we can cite the relevant legislations when it comes to the issue around separation of powers. Remember, because that's how you then, towards the end, say you've made a finding, and then a recommendation would come out of that to say you've breached this particular part of the law or whatever law you didn't follow it, and then on the basis of that, be able to come up with a clear recommendation at the end. So I agree with the proposal that was made earlier, but I think maybe when it comes to the issue about separation of powers, we need to clarify it because when people talk about separation of powers, they usually refer to what Honourable Mokoena is saying. I'm saying members of the public for clarity, even though we understand exactly what we're trying to say. Thank you.
Thanks, Chair. Chair, I think there's nothing wrong with the topic, which is saying separation of powers, because if there's political interference, it's political interference on administrative matters. So again, there should be that separation of powers.
Kunjalo.
Yeah, no, somebody's giving me breaking news that breaks my heart. I'll find a way of introducing it. I take your point. I'm sorry I was distracted because I thought it was important, but we'll find a way of addressing it towards the end, Honourable Van Dam, if you don't mind. We'll find a way of addressing it. Hlaudi, please repeat your point. I'm sorry I was distracted, ma'am. I'm sorry.
Okay, Chair. Chair, I'm saying the topic to me is fine, which talks to separation of powers. Because if there's political interference, it's political interference on administrative matters, which needs the separation of powers. So we can leave the topic as is.
All right. We can put, I'll come to you. So maybe I'll come to you, then I'll take a decision.
Maybe to make a proposal, Chair, rather than putting it as separation of power, we put the roles and responsibilities. Will it not? Because I get the point that the Honourable Motsoeneng is bringing. In fact, it's more loaded as if you're dealing with organs of state. But maybe, roles and responsibilities or duties and functions, just to be more lighter to the point. Maybe.
Okay. No, that's exactly what I was pointing to. Can we make that heading separation of powers and role clarification? Because then it covers everything. Because in some instances it's role clarification. In certain instances it's clear separation of power. Let's put it for that for now, and we can revisit it and see if it looks nice on the 24th. So 5.1 we'll leave as separation of powers and role clarification. So we won't argue about the content of it where it comes to, because once we've agreed on the heading, at some point then we will move them. So for now, don't argue where it should be. Is that okay for now? The headings will be role clarification and separation of powers. It doesn't take away your point, sir, that says at some point we must be able to say, when we talk about separation of powers, this is what informs us. In other words, the Constitution and so on. And we'll find a place to put it in, so that we have both of them. On this one, role clarification and separation of powers as one heading, and we go through 5.1 to 5.15.
On role clarification, just to bolster what Honourable Waters said. So not only speaking to separation of powers, but her duties as a member of cabinet. So the Executive Ethics Code, which details how a minister must conduct themselves, and then the Powers and Privileges Act, which details how a minister must conduct themselves in relation to Parliament. So in role clarification, I think it's very important. We don't have to write out the section in the law. Just say, in terms of the minister's role, the Constitution, Section 92, and the other section, Executive Ethics Code, and the Powers and Privileges Act, so that it's clear upfront what legislation applies to a minister in their role, and then also in relation to Parliament. Upfront.
All right, to try and summarize, remember we are parking somewhere. We'll find a place in the future that will talk to all these laws and legislations that prevail, that might have an impact on our report. Now, whether we put them all up front or somewhere, but we will first list all of them so that people know exactly what we're talking about. The form is what we'll discuss. Do we put it, cut and paste, or do we just put a point? Suggestion from Ms. Van Dam is that we'll have to somewhere say the Constitution informs us, the powers and privileges informs us, the ethics code inform us, and whatever else. So we'll have to find a way of putting it there so that people know that this is not our own ideas, but it was informed by some sort of legislation or law that is currently in place. But that doesn't take away from us going through 5.1 to the end in terms of do we want it, don't we want it, or do we want to amend, or do we want to add? Is that okay, members? Is that okay? Can we go back to 5.1 then? Is there any changes to 5.1 as it appears in the working document? 5.1?
5.11, I've just got some problem with the wording, but it's just to speed things up. Can I submit revised wording? It's just a bit, I'm not very happy with the way it's worded.
The message is this. You don't have a problem with the content. You're saying it's just about wordsmithing it.
Yes.
And that's fine. That's fine. That's fine. We have no problem with people wordsmithing it if you're not going to change fundamentally what we were trying to say, because then it's an ambush of some sort. So it's a grammar, wordsmithing, that's fine. You'll make a note, somebody, that we'll expect Van Dam to come back with 5.11, just in terms of improving the wording. Is that okay? Mr. Motsoeneng?
I was going to suggest, Chair, that the last sentence, however you're going to wordsmith it.
Because, oh, you want to give the last sentence to help her in wordsmithing it. I thought we'll deal with it comprehensively when after the wordsmith proposal.
Yeah, no, I wanted to say that these include ensuring its independence from government and its policies or something, because it can be independent from government. So what I suggested is government interference in its policies and day-to-day business.
You liaise with Ms. Van Dam after she's wordsmithed it so that you can propose, because this is what it's about. It's about deliberation, and we will still come back and argue it. So that's another one that is for further or future consideration. 512? 511 or 512, ma'am?
511, Chair. I just wanted to suggest that if we get the rewording back, that we also make reference to the Broadcasting Act, particularly the Charter of the Corporation, because that would actually cover the political interference, etc. It is clear that the Broadcasting Act contains all of that, how the public broadcasters should conduct its news, content, etc., etc. So maybe if we could just make reference, in addition to the Constitution, also the the Broadcasting Act, in particular, the Charter of the Corporation, as is in Chapter 4. I do that, Chairperson, just to say that when we deal with the details of it, I would like to include reference to that. But I'm fine, we don't need to deliberate the detail now.
That's fine. You know, I keep on coming back to the point that we were trying to make, that let's stick to trying to reflect the evidence that was presented before us in one section, and let's stick to what is guiding principles in another section. All right? So I'm not sure that, and maybe I'm wrong, maybe people can correct me. I don't recall anybody coming here and saying the broadcasting charter X, Y, and Z or whatever in terms of presenting evidence to us. But it could be something that is a guiding document, I'm not sure. So does it fit to where Waters is talking about right up front, or does it fit in 511? Because remember, we're talking to 511 right now. Nobody's disputing that it must be there. The question just is, where does it belong? All right.
Chair, or it can go to evaluation of testimony, but I can recall, I just can't remember exactly who referred to that, but I will go back to the notes.
If it was referred as evidence, it's fine. I'm just saying we must be guided by that all the time. We need a champion for that. First of all, Van Dam, you are taking responsibility to reword 511. Is this thing that you're talking about part of 511? Is that what you're suggesting? So it means that you'll have to give your input to Van Dam. Mokoena, whatever input you've got on 511, will you give that to Van Dam? Van Dam, you'll present that, we'll argue it between the end of the day today and tomorrow. So can we then say, with that said, we can go to 512? 511 is outstanding? Is that right? 512. Prof.
Thanks, Chair. On 5.12, where the sentence says witnesses suggested that the Minister often interfered in the board's business, I would have perhaps loved to see some specifics that relate to saying, for example, interfered in the board's business by way of this, for example, 1-2, rather than bringing an element of generalization. Because when you say just interfered, in what way? Somebody who gets this document must have a picture of how the minister interfered, where perhaps the witnesses were saying the minister did 1-2. That one we are giving a picture of how the minister interfered without rewriting or bringing in everything that was said, but as a way of giving at least, say, 2 examples that he interfered in this manner. Thank you, Chair.
Who are you suggesting is going to do that? Because, Tina, it's our responsibility as MPs. When you say somebody must go and do it, who's going to do it? I'm being very serious, members. We can't come here and say there's a gap here, because we had read this thing. I thought when we had come here, we would have come and said, these are my proposals. Otherwise, we will be here until midnight. So we agree with your point, Baba. We agree with your point. And nobody seems to be disagreeing with the sentiment of it. We will do it on our own, but I think that the culture must be, if I'm proposing changes to this clause, I must come with the proposed changes. You can't delegate that to Cindy and to the backroom staff. I'm just appealing that members understand we operate in that fashion. I'll come to you, sir. So I think we agree with you, the sentiment, that it's very general. Are you volunteering to give us 1 or 2? You can work with any one of us here, because you've got all the documents. If you can come with 1 or 2 for us, by the time we reconvene tomorrow, it'll be fine. Is that okay?
That's fine, Chair.
Thank you very much.
Although I could even give 1 example.
Even if it's 1 example, yeah.
Just now.
Even just now, it's fine. It doesn't matter when. Just give us the example. We don't mind putting it in the document, but don't outsource the work of MPs to the backroom staff, because we're not going to accept it. Yes, sir.
I was going to help him with areas that were identified.
Help him offline. Help him offline.
Yeah, so I think it's fine. He's going. No, I'm not going to work with him. We can deal with it. We'll help him when he comes in.
All right. We all agree that that sentence, I mean, that what do you call it, a clause or paragraph is fine. We will just be specific in terms of, even if it's 1 example, it's fine. 2 examples is even better. Agreed? Thank you. 513, Kubisa, you'll come back with us at some point. 513, Honorable Killian.
Chairperson, I want to propose, the contents is fine, it's just a very, very long sentence, the first one. We could, it is the sentence, testimony from witnesses, including the minister, demonstrated, you know that sentence, but it goes up to the second last 2 lines, but the last 2 lines. So my recommendation would just be, could we not perhaps ask the legal service team here to just, because the essence of it is fine, it's just to capture it in more understandable language and in shorter sentences. Could we do that, or did you want us to do it ourselves?
No, I want you. I don't want tomorrow for anybody to say that this was a document prepared by the legal section of Parliament. We must take ownership and we'll defend it.
Okay, Chairperson, I will then reword it, and can I come back with the rewording?
That's fine. I hope somebody's taking notes of all the sections that need to be reworded and who's taking responsibility. And once they've been reworded, we'll bring them back to the floor. Are members happy that we'll wait for the rewording and come back? Yes. 514? Let's take Mokoena and then take Swartz.
Chair, 514 is fine. I would have added, though, at the end of it, that it must also be noted that an amendment of the Broadcast Act is now at the NCOP to give powers, for amendment, to give powers of hiring and firing of board members to the minister. Because we did get that information today. Yeah.
So you're suggesting that we increase this by saying that there is some work in progress somewhere?
Yes.
That's what you're saying. Cindy and then will try and capture it as Singh has suggested later on. I mean earlier on, as we capture them, that as we understand them, we'll either put them in bold or put them in whatever. But I had seen Swartz. You want to talk to this point first?
I just wanted clarity just to say there's some work going on this point. As Mokoena was saying, who's doing the work?
NCOP. Is that what you're saying, Mokoena? He's saying it's at the NCOP level.
Yeah, we'll have to check where the document is, but I think they did say that it's left, it's gone to the NCOP now, or something like that.
What?
No?
What?
Okay.
All right, breaking away from Parliament for now, the Parliamentary Ad Hoc Committee discussing their working document into the inquiry of the SABC, and they are hoping to formalise that document by Tuesday. So far, they're going through chapter by chapter, clause.
No, that's exactly the point. I don't think it has been introduced yet. If it was withdrawn, it was contested, and all those type of things. At this point, it's not been introduced. But remember, we're not talking about our opinions, we're talking about what people said. If we put in here the statement you make, sir,
No, Chair.
we must be able to say so-and-so said it, because it's evidence either oral or in writing.
No, the two young persons who came here, I can't remember whether it's SOS or, but the guy, the guy who was giving evidence here, he said that the amendment to the Broadcast Act has been sent to the committee, the portfolio committee, yeah. And that it's gone to NCOP. I'm not sure whether it's NCOP, but there's work being done on it.
I thought Honorable Swart was correct, maybe that rather than just making it the issue and make a point on it, we deal with it under observations because it falls directly on the same issues of legislative processes. You remember there was a point of yours that wanted to do the issue of in place before the MOI. So I'm going to propose here we put it under observation. Let's deal with it when we are there rather than making a clause on something that is still in the process of the NCOP and all of that. It may not come out well, in fact, at the end, but we can make it as an observation as we deal with it in that level.
No, Chair, there is a draft bill that would take the powers away from Parliament to appoint the minister, to appoint the board members. I've got a copy in front of me. So we can take cognizance of that. It's in Parliament. Although there might not have been evidence, I think Mr. Mokoena is correct. Someone alluded to it. It was either the minister or someone, but we can, in our observations, raise concerns. But we need to remember that the Communications Portfolio Committee has already passed a Parliament will not be able to appoint the members of the board. It will be the President on recommendation of the Minister. And I think, Chair, as I quickly read that would amends the appointing body. And that is the heart of the difference between us and the Minister. And I think we will deal with that in our observations. It's a very critical issue.
The bill is indeed before the Communications Committee. It hasn't been dealt with because there's some legal matters related to the bill. I don't think we should even discuss it. except maybe if we want to give a recommendation or an observation as a committee on any proposed laws that seek to remove Parliament from appointing board members, but I don't think we should refer to it at all. It hasn't even been discussed yet.
Chair, I don't agree with Honorable Van Dam. I think this bill, irrespective of where it is in the processes of Parliament, there has to be a decisive recommendation by this committee, because it does interfere or it impacts negatively on the governance of the South African Broadcasting Corporation. And I think it's not a point that should just find itself in the observations. In fact, we need to elevate it, because it's got to sensitize everyone. Otherwise, we will, as this committee, will be guilty of having given, the minister the blanket to do as she wishes. We've seen what has happened with this interference with the processes with the executive, and giving the executive sometimes wrong directives. Now, we can't be party to that, Chairperson. I think we need to elevate this point, and I think it's key to our findings.
No, Chair, yeah, just to reiterate the point, because I don't know what happens with the regulations in the communications. The only way I know that this has happened is because there was evidence in front of this committee that said that this is what has happened. And I think it's important that we mention that, so that when we make the recommendation, it's based on evidence that we have found in the thing. So I think we must mention it as evidence that it was mentioned, even if I don't care about the wording, the wording of it. Even if we just say that it was alluded that whatever, that's fine. And then in the recommendations, we then deal with it properly and say, this is, but I agree with Dr. Khoza. We must recommend in a very cogent way to the committee as to what must happen with the thing. Thanks very much.
We're still dealing with 513, is it? Yes. Yeah, so that we don't lose focus. And I mean, I agree with you. What we were basically saying, when I say we, I'm talking about the authors of this document, of which I was one. We were basically saying that from evidence delivered, it looked like people one day used the Broadcasting Act, one day used the Companies Act, whichever one suited their purpose at the time. That's what we were saying, because we picked that up from evidence. Now, and that's why I'm struggling to understand what's the difficulty with outside of the wording. What's the difficulty with the principle? Because it was definitely testimony. And we hear that, and I'm saying in our observations, we could say it was testimony, but that testimony is based on non-existent law. If we're saying there's non-existent law, it's based on, but that it was testimony can't be disputed. Somebody said it. So I'm trying to understand, why are we taking so long on 513, or what was the problem with 513? Let's take Van Dam and take Mokoena.
I think that's the point I was trying to make. Maybe I didn't make it correctly. 513 deals with testimony about things the minister said. The draft bill, I don't recall the minister mentioning it. That's why I'm saying it doesn't belong here, because it wasn't part of the testimony. But it is certainly something we can include in our observations and our recommendations, but it was not part of her testimony. Yes, so in terms of 513, in terms of the minister and whether or not she said the Broadcasting Act, the Companies Act trumps the Broadcasting Act, that wasn't part of her testimony. So that is a separate issue which I believe we should deal with in the observations and deal with in recommendations. It's not part of 513.
The boss here says it was testimony.
Was it? All right. Okay.
From Media Monitoring and SOS.
But not the minister's testimony.
No, we agree. If it was not from the minister and from somebody else, you're quite correct. We will then correct this thing, because remember, this is a working document. Or we can say there was testimony. It might be wrong to assign it to the minister, but that somebody came and said, this is a problem because people use it. That is indisputable. We can go back to the records and find out who said it. Motsoeneng.
Yeah, no, Chair. It definitely was testimony. I must reiterate that. But the point that I was making was not to 513. It was to 514.
No? Oh, yeah. All right. In terms of 513, we agree that there was testimony. All we need to do is to find out and correct who were the testifiers, if that's a correct English word. No, I'm saying 513. Muskilin is going to reword 513, including question marks around the beginning. Who gave testimony to that effect? Muskilin, are you taking note of that? No, that's fine. Yeah, because there's some dispute of who's mistaking. I'm saying when you do it, just fix that up so that we don't go back to this argument. 514 is what Motsoeneng is referring to. So 513 we're ticking as outstanding, agreed to but outstanding in terms of improvements. 514 was what Motsoeneng was talking about. And you were saying, sir?
No, in 514, all I was saying is that there must be an addition. I don't think there's anything wrong with 514 as is, but there must be an addition to say that it must also be noted that an amendment to the Broadcast Act is now at wherever it is, Communications Portfolio Committee, to give powers of hiring and firing of board members to the minister without ratification from Parliament.
All right? It's factual, we can defend it, and it was what somebody said. So I'm looking at everybody. In essence, what he's saying that somewhere we must note that there is something happening that will give power or change the power relationships between the minister and the board in terms of hiring and firing. That's what he's saying, isn't it? And we agree with that one. Yes, ma'am.
Chairperson, the only addition that I just wanted to make on 514 is that the Broadcasting Act, Section 13, also refers to the deputy chairperson of the board. So I just want to suggest that we include there to say that the appointment of the board chairperson, board deputy chairperson, as well as other executive, non-executive directors.
Are we still on 514? 514.
Yeah.
Yes, sir.
No, the issue of the legislation, Chair, do we want to deal with it just general, or do we want to go specific into a particular clause of the bill that is before Parliament? Rather than, if we put it just general, the bill has many, clauses on it. Maybe we may want to zoom specifically into what is it that takes the powers away from Parliament, or any other clauses in that particular bill that is it's already now in the NCOP. So it means that. But Motsoeneng is saying something about NCOP.
It's before the NA.
Yeah, so it means that maybe we may want to zoom into that, because I think Honorable Khoza in fact puts it clear that these are some of the issues that we have to guard and make sure that they don't proceed. But let us be specific. What are those issues in that bill in particular? Which areas that we are very much concerned about? And you put it forward rather than just leaving it general, Chair. So maybe what we may want to do here in this point, you may want maybe to task the legal team, because that bill has never served before the committee. It's only those who will beneficiary on this point will be those who are serving in the portfolio committee who have seen the side of the bill. We have not seen it. Maybe we task the legal team to look at that particular, in line with the principle that we are driving as this committee here. So they can then come back and then say, what is proposed in the current bill that is before Parliament is contrary to what we are dealing with here, and this is how it's going to impact. Then we can then package it proper. Because if we leave it and we continue with this, the next thing that committee has passed that bill, it reverses everything that we'll have done into this process. So I'm proposing that we sort of task the legal team to look at that and come back to us. Thank you.
Okay, so we are asking this committee to at least alert and be proactive so that whoever deals with it somewhere else, these could be the consequences if it's implemented in whatever form. That's what we're basically saying. All right. Cindy, are you guys able to capture that? All right. We'll try and find a way of proactively in the evidence, because it will have to be covered in observations and recommendations going forward. We're happy with that one. All right. 515. Yes, Mr. Swartz.
Chair, this is a legal provision relating to conflict of law again, and I would suggest that that again comes in the framework, but there is a conclusion that is reached here. This reaffirms that the application of the Companies Act over the Broadcasting Act is unlawful. That's quite a strong statement, and it's justifiable. But I think the introduction part will come into the paragraph dealing with the conflict of laws. That's Section 8 and the conversion, because one's got to explain the whole process, and that's why the minister holds the view of the Companies Act trumping the Broadcasting Act. So we've got to go through the whole process and then reach the conclusion why we legally say the Broadcasting Act trumps the Companies Act in certain circumstances only. And again, it gets back to the bill, which then has a relevance to that as well. Thank you, Chair.
Other comments? No. Question is, Mr. Swartz, does it fit under evidence or does it fit under what I will now call the waters area? I mean, is this just a general...
It's not evidence, it's
not
law.
evidence, it's
a
part
statement of the law. Yeah.
Okay. Happy with that? Oh, okay. Yes. Oh, we'll call it the Mokoena era. Then we know what we're talking about. All these standing laws and regulations that will inform us. That takes us to financial management 6.1.1. Any comment, Mr. Singh?
Thank you very much, Chair. Chair, everything from page 10 to page 16, the top of page 16, from item 6.1 right up to 6.6 on page 15, are a factual account of what is contained in the Auditor General's report. Right? It's taken from there, I would think, directly. So maybe where we say financial management, we could say the Auditor General highlighted the audit outcomes of the SABC for the last 3 financial years as follows. Then the findings, the irregular expenditure, the irregular expenditure for the SABC Group, compliance with laws and regulation, fruitless and wasteful. We've got to give that an introduction, because this is what the Auditor General said and has reported. So I'm suggesting we take that first line, put it there under financial management, and then put findings, irregular expenditure. And I don't think we can change any of this, but this is definitely taken from that report, and they can reconfirm that as they proceed with giving us the document.
Before I get to you, you're saying amen to that? Okay. Just looking at Google, we literally took this from the AG's report.
Yes, Chairperson, this was taken from the audit report of the SABC, but we added some of the things that came out when the Auditor General came, because this relates to 3 years. So it doesn't relate to 1 year as it happens in the audit report.
I think the point that Google is making is that this is directly submissions from the AG. So there's no contestation about it. Whether it was reflected in the current finance annual statements, whether it was reflected in the submissions, there is no personal views other than what the AG has said here. So Singh's point stands. We'll come to you. Just take us back, sir, to what you were suggesting the opening sentence to be. You got that?
Yeah.
Okay, no. Cindy has got that. That's fine. Let's then take Killian and Swartz on the proposal and let's start with Waters, Killian and Swartz, and cause. Everybody wants to speak, okay? On financial management, up to 619 or whatever it is.
Yeah. Chair, all I wanted to say was 6.2.6 is a duplication of 6.2.5. That's all I wanted to say. On page 12 at the bottom. Duplication of 6.2.5.
Chairperson, that was my point as well. Just in addition, on page 11, there are slight grammatical errors which we say we will come back to later.
Swartz?
How many hours do I have, Chair? Because there's a lot on this issue.
On the financials?
Yes.
A lot that you're disputing in terms of being factual?
Nothing, I agree with what's been said so far.
No, but remember, we're not dealing with observations.
No, but the financial management report that was part of the reading matter is 250 pages. It goes beyond the financial year, and it speaks directly to the going concern of the SABC, which is part of our mandate. That's not mentioned anywhere here. On page 153, it says management of the SABC has prepared financial statements on a going concern basis as per the Companies Act. During the audit of the financial statements, we noted material uncertainties which cast significant doubts on the entity's going concern assumptions. Then it goes on to speak about cash reserves subsequent to the financial year, up to May, and indicating that as a going concern, the Auditor General has got major concerns. And that is a whole section that needs to be dealt with. And that's just one point out of 230 pages. Now, we're obviously not going to refer to all of it, but there's procurement, there's vacancies, there's so many issues in this management account. What I can do is I can take out a few highlights out of this and suggest for insertions. Maybe that's the way to go, and we can consider that.
From the management report?
Yes.
And that management report we sourced from?
The Auditor General provided.
The Auditor General provided it. So that we understand the authenticity of where that information comes from. So the proposal that Honorable Swartz is making is that this was picked up from the half an hour or 1 hour presentation by the AG. It was picked up from the annual reports, but we never took into consideration the management report stuff. And Honorable Swartz is saying we need to take from the management reports stuff that he would think are worthy. And as an example, you're certainly not going to take 200 pages.
We should all try to read it because other members might have other views. But this is the financial management report dated 31 March 2016, but it deals with issues of cash flow subsequent to that. So I will highlight some of the issues. The status of this is it must be read in conjunction with the financial reports. So there are issues here that are of great concern to me, and that I'm sure the SABC would respond to as well when we put it in an interim report.
Just before we carry on, Cindy is indicating to me that it didn't come from the AG, it came from Mr. Itani, because you recall the AG said it's a management property and the SABC didn't want to give it to us. So it raises a few questions for starters. The authenticity of it, that's the first question, and I'm not saying it's right or wrong. If we're going to use that as a source, so I'm saying as we talk to it, that's what we need to raise.
Sorry, Chair, I thought it was from the Auditor General,
well,
but I don't know, it's part of my documents that were provided to me. So
that's why we deliberate, because we will say to you that and if you feel that it's worthy enough to put it in there, I mean, we could put a sentence, and we will put it somewhere, that going forward, the relevant authority must get these documents, because remember we had summoned those documents. Scoper, the portfolio committee, somebody must get those documents because we believe that those documents will go to the heart of some of the rot. I mean, we could do that if we wanted to do that because you've got some evidence to that effect. But I just don't want us to use evidence, especially if it's in writing and not being said verbally, that we don't even know the authenticity of, if I could be want of a better word. But I'm saying that's, as we talk to it. I'd noted Singh that wants to talk to it. I'd noted Killian that wants to talk to it. Khoza did want to talk to it. On that, we're agreeing that what is here is finished and clear, including the sentence that Singh included. We're just talking to the management reports. Singh,
Thank you, Chair.
Killian, Khoza.
Before I talk to the management report, Honorable Kwankwa will be leaving us. He's got another commitment. He'll join us later. So I thought I'll just mention that. And then, yeah, Chairperson, there's no gainsaying that the issues that Honorable Swart has raised from the management report are very, very important to the sustainability of the organization. But my understanding from serving on SCOPA for many years as yourselves is that the management report is an exchange of correspondence between the Office of the Auditor General and the management of the entity or the organization. Many of those issues that are raised there are normally addressed before the Auditor General presents the final report that's tabled before Parliament. Now, I agree with you, Chair, we've got to be a bit careful about using what is contained there, unless what is contained there is in the report of the Auditor General, which I think Gugu must check. Because the issue about going concern is something that is always raised when it comes to an entity. So I think we need to check, because if it's factual in the Auditor General's report, then we can use it here as part of testimony, because it is a written document. But I would be hesitant, like you, Chair, just to take certain things from there, albeit the fact that they're very, very important, and include it here in our document.
Chairperson, yes, as far as the going concern matter is concerned, I agree, but I feel very strongly that because we asked for a copy of the management report, we can verify from the Office of the Auditor General, because they have asked us to get it from the SABC Board, failing which they can provide it to us. The fact that it was now provided by one of the witnesses, weakening this case, but it contains such very important information with regards to the DAF, Delegation of Authority Framework, and amendments to that, resulting in so many of the problems, systemic problems. The fact that board resolutions were not taken by a core-rate board. I just feel I would ask members if we can perhaps just make a note and come back on this matter tomorrow. If they could go and read page 259 of the management report and towards the end. It is very important, and it drills down to the core of the governance problems and the resulting fruitless and wasteful expenditure that has come over years. So I really want to suggest that we don't ignore this document, Chairperson. Whatever way, we have to just make sure that we dot the I's and cross the T's. Let's do that. But the whole matter of the memorandum of incorporation, the irregular introduction of that, everything is addressed in the management report. And therefore, it is a finding of the Auditor General. Auditor General's documents that goes into the annual reports usually are very superficial. But if you start scratching, they drill down to the detail. And we cannot ignore that. Then we have not done our work properly and efficiently, Chairperson. So I really want to suggest that you just allow us, maybe if we can bring one or two elements from that and bring it to the fore to substantiate our concerns with regard to the hiring and firing and all of that that happened. Also, the fact that supply chain management went out of the door. I think we can get it in this management report. Thank you, Chairperson.
Chair, I just want to recommend that probably the heading on 6 should be, we should take it directly from the terms of reference, as opposed to saying financial management. And I'll tell you why I think the financial status and sustainability would be more accurate than financial management. Remember, number one, we must remember, some of the information that we got from the different witnesses is not necessarily the information that you will be getting from the AG, because the AG works on the basis of sampled information, of which even that sampled information, the AG had doubts about its reliability and credibility. Now, Chair, there are also issues that are central to the governance issues at SABC, and that is the procurement issues. Everything that has been going on at SABC center around procurement of the affidavit that we got from other people, the submissions that came from other people, especially the report of OTA. Is it OTA? What OTA? OTA. And also even the evidence of Nompilo Dlamini. Those are the kinds of issues that should be covered under this, which will then assist us to arrive at the conclusion in terms of the financial status or position and sustainability of SABC. And it will then assist us to come up with appropriate recommendations, the recommendations that are speaking to the terms of reference. That's my suggestion, Chairperson.
The main issue, obviously, is the terms of reference that guide us to deal with the financial status and financial and sustainability. I'm going to propose, Chair, from the point raised by Honorable Khoza that we sort of go deeper, because currently what you have picked up here is more of a report. I think what we need to do, Chair, is that we task a team that sits and look into all the financial matters. And then after having done that, we then look at the sustainability part of it, because currently the report presented does not deal with sustainability, meaning that moving forward with the hours on it just to deal with the mandate, because the mandate there is very clear and it starts with that. In fact, our mandate starts with the financial status of SABC. At the same time, what we then, it's the response to the Auditor General. The report to Auditor General, meaning that your action audit plan will have to be looked at. Does SABC have capacity to deal with such matters as irregular and fruitless wasteful expenditures, Chair? They've came out quite very strong. I think during the presentation we'll have picked up that.
Yeah, you know, honorable members, and again, I'm not talking as the chair, I'm talking as a member of the committee. You know, matters that we're talking about here can never be dealt with in 2 days. They just cannot be dealt with today. This thing of sustainability is not something that any one of us could sit here and take a authoritative view on. And that's why, personally, I tend to support Singh's point. Because you see, the Auditor General is the supreme audit body in South Africa. And these things you're talking about of unauthorized, and we're not going to deal with all of them, but it's symptomatic of the problems that are there. And I would be very comfortable if, on the basis of what the Auditor General has said to us, we make firm and proper recommendations. Unauthorized expenditure or wasteful expenditure to the tune of 92 million was identified. Go and find it and get people to pay. That's not disputable because it's the AG's report. Everything else, I think somebody said it earlier, or when I say earlier previously, that we might need a separate and focused effort to get into the other meat of the AG, the funding model, the sustainability, and so on. And we could say that we think that it is a recommendation that must be taken forward by whichever authority. But I don't want us to labor under the impression that we're going to ever do justice here, and when we recommend on the basis of whatever we find, it's challenged by anybody. I'm just cautioning against that. Nobody can challenge us on if we talk to the AG's report. The rest, I'm suggesting that there's nothing stopping us from saying, from the evidence we've gathered from you, Sir, Mr. Swartz, evidence we've gathered from whoever, it is clear that there is a need for the incoming board to focus on addressing the sustainability, addressing all those other things. Because in that way, remember, part of our mandate was also saying, we must be able to say to the incoming authority, what is it that they must do? Because we are not the superpower to solve all these problems, but ours, at least through this exercise, we've identified it. So the proposal that I want to put, and I'll come to you, Chauke, I feel strongly that on the basis of AG's report, we make a finding. On the basis of everything else that Honorable Khoza spoke about, that Honorable Swartz spoke about, we can put it under observations and a recommendation, which is a recommendation that must be implemented, which must be implemented by the relevant authority going forward. I'm saying that is, for me, ultimately we must defend this report. We must defend this report, and we shouldn't be opening up ourselves unnecessarily. And we should also not be scared to say that there are deep-lying problems, financial, as you are raising, Honorable Swartz. So I'm saying, and we don't have to resolve it today. Maybe we can go and think about it and talk to colleagues that are more clued up than we are. I'm just cautioning that we shouldn't be thinking that we will come up with a recommendation on the sustainability or otherwise of it. That's just what I'm saying. And maybe these are one of those that we should leave for later. But what I can put my head on the block for is that from page 1 to whatever the pages are, on those we shouldn't even have a problem. It's the AG's report, it's the AG's emphasis of matter, and we can make a recommendation on those and get that out of the way. And what you're talking about, Swartz, could become from page whatever to page whatever. That's the proposal that I'm making. Sir.
I think it's dying. Can you hear me now? Yeah. No, thank you. Oh, you're not hearing me all along. So I thought I didn't hear him. Thanks, Chair. No, thanks, Chair. So what we then do, Chair, in line with what you are proposing, Chair, is that we then take, based on the witness that came before the committee and raise issues of what we will call it fraudulent financial activities. Maybe have a say in that particular area, Chair. Maybe through in our discussion, but make a recommendation that sort of begin to deal with action that must be taken around those issues. Then I'm okay with that proposal that we are putting forward. But we must not miss the input that was made, that they should show whoever, the one who was dealing with financial matters. And that information, I think, is very critical. Currently, is not covered here. We just have to find a way of bringing it. And then once we have it, then from there, we are able to make a recommendation on it because it's in the report. And that will, in fact, enforce the recommendations that we'll want to put forward on that matter.
No, Chair, I was going to suggest that what Honorable Sources was suggesting should go under our observations. Because I think it does take our own investigation to figure out what happened and so on and so forth. That's one. Two, even if the Auditor General's report was taken off directly into our report here, I wouldn't have a problem with that because it is evidence that we got. I would suggest, though, that because we mentioned that Sabelo Xabisa transaction, we should also look into Vision View. And I think we must mention it because it's 42 million rand that was procured irregularly. So I would just suggest that we mention it so that when they do the investigation, then they can look at that as well. Because later on, when we do recommendations, I know, for instance, that I'm going to suggest that we do a general but detailed forensic audit of the entire SABC, not just specific transactions. Thanks.
No, Chair, I'm happy, and to a certain degree, but as a member of Parliament for many years standing, I've never dealt with such a report, and from now on, I'm going to ask for this report, because there is far more in this report than the AG reported to us.
Yeah.
And so I know the AG focused on irregular expenditure, but there is so much more in this report, even relating to the contractors, the independent contractors. We had all that list of people. There's evidence in here relating to that the tax was incorrectly deducted at the wrong rate. There's evidence in this. So I would like at some stage so that the SABC can also respond to this, because I understand this is a working document with the Auditor General, and you have discussions. But on what I said earlier about the going concern, and I accept the status of this document, I've got no reason to deny it. The management response to that statement that of technical insolvency is no response. Auditor's conclusion, no response is received, therefore the finding is deemed to be factually correct. Now there's a finding here of possible uncertainties, the possible technical insolvency. That is crucial. Why didn't the the Auditor General not indicate that to us, or is that not in the ambit? So I'm also helped to a certain degree by Mr. Singh saying, well, they don't normally raise all these issues. But there is a lot here, and I'm definitely going to suggest one or two of these issues are put into our observations, and when the SABC responds, they will then have the opportunity to say, no, that was then, the situation has changed. And I think that would be fair to them as well. Thank you, Chair.
Thanks, Chair. I feel like we're talking around in circles. We're at Part B, which is the summary of evidence and testimony. In here, a summary of the AG's evidence and testimony. Can we not then just include an extra section which says the management report further revealed that? And that's it. There's no need for anything further.
No, I thought that's what we were saying. That's why we were saying let's agree with Singh's part as part one and agree with it and get it over. That's from page whatever to page whatever. The issues that Singh and Honorable Khoza and Honorable Chauke raised are important, but that should come under another heading. And if we agree that it comes under another heading, amongst ourselves we must at least then craft a paragraph or two to that effect, to come into the report, whether it's observations and then recommendations, that's not a problem. Because remember we said we'll add to, we'll subtract from, and we will delete if necessary. So, Honorable Swartz, there's no problem. I think however we do it, all of us or some of us, let's try and find a way of putting that as Section 7 or Section 8 or Section 15, it doesn't matter. But it must at least be presented before the end of the day tomorrow. So going back to the financials, which is point 6. Points, yes, ma'am.
Sorry, Chair, I don't want to miss anything. Could we have a quick 5-minute comfort break?
We're going to do that, yeah.
Great.
Can we, no, the point that I was making is that from page 10, which was the original suggestion, up to page 16, the first 2 lines, can we tick all those? And the only addition is what Honorable Singh said as the first line. And Honorable Swartz and the others will then try and package this thing that talks about sustainability, about the management reports. And even if we don't discuss it today, we'll come back to it as something for tomorrow. We agree? If we do agree, it is 3:20. Can we be back at 3:30? What time? Oh, okay. Coffee was supposed to be at 30:30. We'll check if we bring it forward, but if we can't, let's be generous and allow you to, because we're going to detain you here for a long time. Can we agree that I'm going to ask Cindy them to try and fast track it? If not, then you've got a 10 minutes bonus from now until 30:30, and then tea will come at 30:30, and you'll be expected back at 3:45. No, I'm saying I had made a proposal that we work until 6. Can we, maybe at 5:30, see, does it make logical sense, and we take a decision? But everybody would have budgeted until 6 o'clock. But I'm sure because you guys wanted a short lunch, you could have a long night as well. We could work until 12 if necessary. But yes, we have budgeted until 6 o'clock because we're preparing a meal for you at 6. But can we then reconvene at 3:45? Thank Honourable members, as we move, things change. Just to get a sense from members, consulted with the staff, bearing in mind that tomorrow is Friday, and as we always say on a Friday, people like Mike Waters and Vincent Smith are migrant workers, and we'd like to leave at 3. And there was a proposal whispered in my ear that if needs be, we will work beyond dinner. In other words, we will break at 6 o'clock for dinner. Depending where we are, we'll take this decision at 6 and come back so that we are able to leave at 3 o'clock. Is that our backroom staff are comfortable with that? So at just before we break at 6, we'll see where we're at. And if needs be, we'll come back for an hour or 2 to make up for tomorrow. And again, starting time tomorrow, depending on how far we are. In principle, we agree? Thank you. So there will be, Cindy, if you can organize dinner at 6 o'clock sharp. We will break for, at the most, half an hour dinner and come back and try and push as far as possible. So that's done and dusted with. And the second part of it is honourable members, I'm reluctant to always focus on anything other than our work, but sometimes it is important that we do that. A journalist and I'm led to believe that it is now in the media and probably will be once again news at 7 o'clock. So we'd be failing in our duty, honourable members, if we don't raise this matter. A journalist, even after we made an appeal for fairness, if not anything else, and accuracy, has tweeted, and I quote, "MPs acknowledge that the leaked document has been tampered with, as there are parts missing from it." Now, we started this morning by saying, first of all, there was no leaked document. Secondly, we deliberately went to random pages from a document before me and asked the question, on page 7, do you see this? On page 18, do you see that? On page 22? And without fail, everybody had the same document. And thirdly, if this journalist bothered to even consult the document that was so-called leaked and compare it to the document we're talking about today, it'll be very clear it's the same document. Word for word, dot for dot, T for T. So first of all, we want to preempt any misrepresentation out there that the document we're working on now has been tampered with, as there are parts missing from it. It's the furthest thing from the truth. It's the furthest thing from the truth. And secondly, it is an attempt to derail what is something that is far more important than media profit and sensationalism. Far more important than media profit and sensationalism. This is about the people of South Africa. It is this committee that at one point argued for the freedom of reporting and the media in this country when we started here. But we must condemn in the strongest terms deliberate misinformation as the message that I've just read now. No document was tampered with. You can continue to refer to the document as leaked, that's fine, but no document was tampered with, because we're busy working through the document from the first word to the last word. So even if there was a tampered document, that tampering would mean nothing because we're going through it in a transparent manner. I don't want members to comment, please, in your individual capacity, because we just will fuel what doesn't need to be fueled. This is the formal position of the committee. No document was tampered with, and we appeal once more to our friends in the media. Please desist from distributing false information. We will at one point or at some point going forward actually name and shame these journalists in this committee. We will have to be forced to do that. It's not necessary. We've never been adversarial to the media, but this respect is earned. If you disrespect this committee, you can't expect that this committee will respect you. I thought it was important I say this to members because I don't want any member to respond, whether in your personal capacity or in your party capacity. This is the position officially of the committee. We'll close this matter at that point. Is that okay, honourable members? Thank you very much. Can we move to page number 16? Supply chain management, stroke-related matters. Honourable Singh.
Chair, thank you very much. Before we go there, have we got agreement that some of the elements of the management letter will be contained in our report as part of testimony? And Honourable Swart and Ms. Shabalala will work on that for us.
Indeed, we have agreement before we broke for lunch that between Honourable Swartz and Honourable Khoza, they'll work with Google so that those important points are not left out of our report, and we can then argue about what recommendations and observations we put later. But indeed, the report that you will receive on the 24th will have that in it. And hopefully, Honourable Swartz and Khoza and others will be able to present at least what they think should be reflected in that report before close of business tomorrow, so that we have some sort of a sense of it. Is that an accurate reflection, Swartz and Khoza? It is. So yes, sir. Yes, sir. It will be reflected. I mean, we will capture it. We won't miss it, and we will head it accordingly in terms of the source of that information. Supply chain management, 7.1. Can we get initial comments from members? Anybody? 7.1. Did I catch you off guard? No, I did. 7.1 talks about testimony by the group executive procurement, and he pointed out a few things. Are we comfortable that it is accurately reflected and we'll be able to defend this part of the report? Ticked? Yes, Honourable Motsoeneng, and then Honourable Chauke and Honourable Swartz. That's 7.1, eh? 7.1?
Yes.
Yes, Kwena and then Chauke and then Swartz.
Okay, so there was, I think it's important, we must mention Vision View. It's 42 million bucks.
that you're proposing, how do you craft it, sir?
I'm proposing that I think we can't be that glib about such as Sekela Xabiso. We must be specific that Sekela Xabiso was whatever, vision view, so we must mention specifically what contraventions were applicable in the specific issues, in the specific transactions.
Okay.
And there were three of them, I think, yeah, there was Secular Clubby, so vision, view, and something else. Yeah?
I'll be with you in a minute, sir. We just want to, is it not in there? All right. The point that Cindy is making is that 7.1 came from the AG's report, and it might not have detailed what you're wrong.
No, but it says here the testimony presented by the former group.
Cindy withdraws.
Okay.
No, it's correct. Cindy withdraws, and so do I. We will go to the evidence.
Okay.
It was from a Mr. Shushu.
Yes.
And we'll try and glean from Mr. Shushu and elaborate.
That's
and
correct,
members must do that, but on this one we will do it because we'll share responsibilities.
Yes, yeah.
We will try and expand on that one to take into consideration your points. I'll come to you, ma'am.
But I do think that we need to be specific about.
Okay.
They need to have their own bullet points. Thanks.
All right. Chauke, Swartz, and then Van Dam.
No, Chair, I think you have already covered me that that Shushu information will be brought forward. I'll propose that as we do that exercise, we'll have to identify maybe within the 7.1, maybe we make 7.2, the following identified. I'm not sure if we have to put them, or unless if we don't do that, Chair, we package them from what the Honorable Khoza will be doing together with SWARP, and then identify, because those are areas of evidence that was put before us. Maybe what we do, we can, under management report, then have the following as gross mismanagement or fraudulent, what you call transition that is occurred, just to identify, to help us to deal with our recommendation when we go there. I'm proposing that maybe we look it in that way. If we don't put up a clause here, colleagues from the other side will deal with that detail, can maybe package it there and just come with a separate what you call item that deals with fraudulent and so that it helps us even to push to the point that the Honorable Mkwena was pushing for, that maybe at the end on the forensic, if we had to call for that, but there will be something on the ground.
All right. You're not going to get away so lightly, Mr. Chauke. You'll join that team and add that section to it. We said if you volunteer, you contribute. That's what we said. So it's not going to be those from the other side, Chauke. It's going to be us. That's fine. All right. Swartz, Van Dam, do you want to talk? You want to have a second bite at it? Okay, let's take Swartz, Van Dam, and we'll come back to you, sir.
Chair, the evidence didn't only come from Mr. Madoda Shushu. There's also other evidence from other people, and I'll look again at that. But we also got documentation from Dlamini, who referred to extensive supply procurement issues. Now, that's not testimony, oral evidence, but it is documentary evidence that also refers to some of the challenges in that regard. So I think that is something we should also bear in mind.
Can we sometimes work like the Auditor General does? And if we've got one or two strong enough samples of the point we're trying to make, we don't have to exhaust all the points. Is that all right? Because we will have the library there. Because somebody else will come and say, it's not only Shushu and so, it's somebody else. So, I mean, ours is to illustrate the point, and the library will always be there, one for us to defend ourselves and for anybody else to take it. So, the point we want to illustrate is that supply chain management procedures were flawed. And if we can reflect one or two examples to prove that point directly from testimony, that should suffice. I'm just scared that we will regurgitate everything that has been said by other people. So, Mr. Swartz, your point is taken, but we shouldn't try and exhaust everything everybody said. If the point is made sufficiently, it should suffice. Can we take Van Dam, and then Mokoena, you'll be the last one on the point?
Can I make a practical suggestion, Chair? Under supply chain management related matters, we say testimony by Shushu, Tsietsi, and I think Dlamini or anybody else, and then we just group it under one, under the same bullet points. Then we include all the people who said that. I think that would, instead of listing what each individual person said, I think that would make it a little bit easier.
There's a second proposal that might get you off the hook, Honorable Chauke, that we, instead of listing the names, we can say these people alluded to it, and if you want to, as a interested party, you can go to the transcripts. All right, Honorable Mokoena, you the last?
Yeah, Chair, I think we must be specific about certain things. That last bullet point there, abuse of power by certain executives. I think we must be specific which executives, so that when we do a forensic audit, we need to know what we're dealing with here.
That's fair enough. We will also, from our side, try and go and look for the executives who we thought did that. I don't know how easy it will be because we'll have to go through a lot of transcripts, but the point is taken. We will move out the certain, and for consistency, as we said earlier on, let's be specific whether it was this individual. We'll try and do that. And hopefully by the time we meet on the 24th, we would have a name or two, but we'll do that background work if that's all right with you, Mr. Mokoena. Prof. Kubise?
Yes, thank you very much, Chair. I was also going to say the same thing, because when you look at the evidence presented by Nompilo, for instance, Nompilo Dlamini, you see how power was abused, how she was interfered with. We can cite that as an example, Chairperson. Thank you.
All right. Other than those strengthening of the document, can we accept that 7.1 has been dealt with? Yes. Yes. Yeah. Okay. 8.11. 8.11. Sir.
I just feel that we should add the name of the then human resources executive, whoever that person was at the time, to make it easier for referencing. That's it.
And then in all those paragraphs, 8.11 all the way to 8.14, we keep saying the evidence. What evidence? From whom? Can we be a little bit more details about who presented evidence, what that evidence said? Otherwise, it's very vague. We must say, this person said this, instead of just saying evidence. Which evidence?
Fair enough. Like I said, you'll find this throughout the document, because we thought that we would not move from names, but so it will persist all over. But you can always highlight it to us, and we will be consistent to our decision of this morning. Honorable Mokoena? 8.11.
No, I think I'm covered by 8.12. Thanks.
All right, 8.11, we move on? With the exception of trying to put names into there. 8.12, Honorable Waters.
Chair, just on the recruitment policies and procedures, I don't want them in the document, but can we not have them as an annexure for reference, please?
Okay. I think it was one of the documents, honorable members, that we had requested via our summons. I speak under correction. I'm saying we will check it. We will check it. But if it is available, your point is taken. If it's not available, because it was one of the summons requirements that was not addressed, we'll state so before we leave on Friday. All right. Can we take Hlaudi and Swartz?
I just want to check, Chair, is what Honorable Waters raising not what is captured in 8.13 on the recruitment policy? rather than taking it in 8.12.
All right, let's go back to 8.13 and we'll come back to you, Honorable Swartz, to see if it adequately suffices, but we will come back. Honorable Swartz, 8.12.
I just wanted to understand what Mr. Waters is saying when he says it must be attached as an annexure. Surely that's an annexure to the evidence and not an annexure to this report. Because if we have annexures to the report, that's going to be a very voluminous document. And remember, it's got to be printed as an order paper in Parliament, so we just need to be careful. I'm not opposed to it, but I'm just thinking of the practical considerations of this and why this document as opposed to the Broadcasting Act, the Companies Act. So we just need to be mindful of that. Thank you, Chair.
Let's take Kubise, we'll come back to you, Waters.
Just a reminder, Chair, that we earlier on took a decision that will not be appending annexures, physical annexures, the way you put it, but to only be putting in names and evidence so that the document is not a bulky one.
Honourable Waters?
Chair, the reason why I feel that we need to have it even as an annexure to the evidence is the fact that, for example, the Broadcasting Act is readily available on the internet. Anyone can access that if they wanted to. This particular policy, nobody can access it. In fact, we may not even have got it ourselves. You know, that's how secretive it is, and that's why it's important to try and get a copy and make sure that it's annexed somewhere. And I agree, we don't want the document to be, you know, a forest that has to be chopped down. But the fact is, we need to make sure that it's there and it's available for the public if they want to look at this.
I'm sure somewhere down the line we talk about delay tactics and we talk about summonses, and we can talk to it there. I'm not sure if this is one that was not there, but it could well be. But we take the point that all documents we refer to should be available at least in our library. When I say our library, even if it's just the evidence pile that we have, but the point is taken. Anything else on 8.12? No? 8.13, Loliwe, you were trying to make a point at, well, yeah, okay. 8.13, any comments on 8.13? No? 8.14? Yes, ma'am? No, we're saying yes in terms of, oh, okay, I thought somebody was saying yes, they want to speak. And of course, where we have evidence, we will give examples of the evidence. Mr. Mokoena?
Yeah, we did have evidence from Ms. Chabalala, alluding to the reasons why they opted to contravene the procedures. And she gave some flimsy excuse, and I think it's important that we must put it here so that, you know, we know that she lied.
At this point, we're not making judgment. At this point, we just...
No, I'm not saying we must say she lied. I'm just saying that we must mention what she said.
All right. You're saying we must make that another bullet point. I mean, another 815 or something like that. That's what you're suggesting.
Yeah. No, 815. Yeah, 814. So that 814 becomes 815.
Yeah, but I'm saying it must be a separate...
Yeah.
The effect that there was evidence from Ms. Shabalala as to justify why they did what they did. Is that what you're suggesting?
Exactly, yeah.
So we'll look for that evidence. If you have it, you'll point it out to us and we'll insert it.
Yeah.
Is that okay, sir?
Yeah.
Okay.
In fact, I think I know what she said.
You'll find it and you'll give it to us and we'll incorporate it verbatim.
Okay.
We'll try to incorporate it verbatim. 821, any comment? 821, let's take Ms. Killian and then Mr. Singh.
Chairperson, I unfortunately just wanted to take you back quickly to the previous section, and that is just with regards to executive appointments. During the break, members were...
Just hold on, so that we're all on the same page. Which bullet point is it? Or is it
That would then be a bullet point on 8.16.
5816, okay.
Yeah.
Right.
And that is that the evidence was also led that the CFO, which became the group CEO, was appointed through a process whereby he was invited because he served in the Auditor General's office. Now, whereas that was not necessarily an irregular appointment because he was headhunted for the job, we have deliberated and we have argued that the mere fact that a gentleman who was responsible for the audit of the SABC records over some time, as in his capacity at the AXA office, was headhunted and brought on board as Chief Financial Officer, is a concern, because we believe that the weaknesses that were identified during his term at the AXA offices appears to not have been corrected, and there are fears that some of the documentation, the relationship between a person from the Auditor General's office and the SABC finance responsibilities at the SABC could have created a situation where we didn't always have the exact, how do we term it, information at our disposal as Parliament. So the Honourable Khoza made a recommendation that we should consider that. I was just trying to alert her to the fact that I think this would be the right heading under executive appointments, where we should insert a paragraph about the fact that he was headhunted and that he was brought online and then later on become the acting group chief executive officer.
Not on that point, but
okay.
on 821.
Okay, on this very point, again, contributing as a member, Honourable Killian, I hear your point, but I think that there's a thin line. In my other life, I serve as the chair of the Auditor General. And there's a conscious decision from the AG that staff from his office are deployed not only to SABC, municipalities all over, as part of reinforcing. So when we include that, we must be careful not to discourage, because the AG's office is the single biggest institution that has chartered accountants on its books. So there mustn't be an unintended consequence that people will say, well, I come from the AG's office, I can't go and become the CFO of the city of Joburg because somebody has made a point. So I'm just saying we must be careful that we don't, I know it's not the intention, but unintendedly there might be this, that don't recruit from the AG's office to be your CFO because there could be perceptions. I move from the premise that an auditor is a professional individual that should never compromise his or her profession, like a doctor or like a lawyer, regardless of where you go to. I mean, there's those professional ethics, but this is a point that has been made. Let's mull over it, and it's something we can come back tomorrow. You want to talk to that very point, sir? No, if you want to talk to a different point, Singh was before. You can take Singh, then I'll take you. So it's a point that we can mull over, honourable members, and we can include it if we think that it's necessary tomorrow. But Honourable Singh?
Yeah, Chairperson, in reading 8.21, and I was not here when this evidence was taken, it would seem to me that we are starting with making a statement or expressing a view. I would have preferred that we start with the last sentence of that paragraph, where we're talking about the evidence or the testimony. Evidence heard corroborated the public protector's findings that the SABC has over the years lost highly skilled so-and-so. We've got that sentence right at the end. but actually we are referring to the testimony. So I would recommend that we put that ahead of the start of that sentence.
All right, Honorable Mhlanga.
Chair, thank you. The heading of this section, I would appreciate if we consider including purging, suspension, and dismissal of senior staff members, whatever we call it, because that's what it actually deals with. Yes, staff members.
Anything else on 8.21, because the heading we seem to be happy with? 8.21, anything else? No? All right. 8.22, Honorable Van Dam.
Thanks, Chair. Just because this is going to be on record and on file in Parliament for years to come, could we have a list of those senior employees who were purged because they disagreed those people that were purged? Can we just include their names?
To the extent that it's possible, we'll do that. Okay, to the extent that it's possible, we're not sure right now. I mean, from the evidence, I'm saying from the testimony, yes. We're not going to go and look for new evidence. If the testimony was specific, we'll be specific. If the testimony is as put there, then that's as far as we can go from testimony. But we will certainly go and get more detail if possible. And of course, that will then be reflected in our final report as soon as it is available. Anything else on 8.22? No. 8.23? 8.24? 8.24, Mr. Swartz. Is this 8.24?
Yes, just
Mr. Swartz and then Ms. Killian.
I think we just need to add there that according to the evidence, the 8 experienced journalists, we should need to say a sentence, they were reinstated after court action, again with legal costs being incurred. Because we don't say anything what happened with them, and procedural dismissals, but they were reinstated.
I think that's fair. They said so, didn't they? Or we know that. I mean, they said so. All right, we will do that. Ms. Killian?
Thank you, Chairperson. In the one case, it was the 8, but in the one case, it was the contract that was terminated. So to be correct, I think we should refer to them having been dismissed, 7 of them having been dismissed, and in one case, the contract terminated, which
Just
is a little different.
Say for one.
Say for one.
They were reinstated after court action.
Yeah.
At that point, can we go 9.14? Can members just go to 9.14 and see if it's not covered there? 9.14. Or the very last sentence of 9.14. Does it not cover your point, Ma'am Killian?
Chairperson, actually, my point was more with regards to the blanket approach to dismissals.
Okay. Right.
You know, in the case of one, it was a contract appointment, but
We
it was
concede.
terminated.
We concede. All right. we will add that, Cindy. Thank you very much. Anything else on 8.24? No? 8.31, Honourable Waters.
Chair, with regards to the people that were paid out bonuses without a proper performance management system in place, can we not, I don't know how many there are, so I mean there might be a long list of hundreds of people, so we obviously can't name all of them, but can we name particularly the ones that with the highest, you know, the more senior managers and the people with the biggest performance bonuses that was paid out? We could just stipulate a few examples to show maybe how ridiculous the whole system was.
Again, I'm saying all views are welcome. I don't know that it's possible for us to be able to say these were the highest or these were the lowest. I can also tell you from where we're sitting that it was widespread, from secretaries to everybody. So it shouldn't matter whether you're getting 1,000 rand or 1 rand. If your bonuses were paid without performance bonus procedures, that is the principle that we should be talking about. But we will try and do what you do. But from where I'm sitting, I can tell you that because I live in Joburg, and I've got friends that work with or at the SABC, this thing was widespread. Every other person got a bonus. But we will try, Honourable Waters, to make it. My point is, if we make an example of 1 or 2 in terms of names, and there's more than 140 or 400 people there, it might just say, but why using my name out of 1,400 people or out of 4,000 people? So I'm just saying let's consider those things. Remember, honourable members, this report is going to be criticized from today until kingdom come. And therefore we must be, from our side at least, we must be able to be watertight for all criticism. So I'm just worried, Honourable Waters, that, you know, it might be innocent as you and I want to think, but I can tell you, somebody will think it, well, it was sinister, it's not by chance that you said Fana Mokoena. So, is that okay? Sure, I didn't know I can convince people, that's fine. You want to talk to that point?
Yeah, thank you, Chair. You've convinced us. I was just wondering, Chair, in addition to the performance management system that was not in place and that bonuses were paid out to people, performance bonuses, there was also evidence that, and in fact in some of the documents that were tabled last night, there was also reference made to that in testimony, that people were awarded a 50,000 from nowhere bonus without board approval. You know, it was just gifts. So I was just wondering if we shouldn't perhaps just adjust the heading to say bonuses and lack of performance management system, so that we can have 2 paragraphs there, that we can also make reference to that. Should we then come back at the end with our recommendations, that matter could then also be followed up to make sure that the incoming interim board would in fact determine who took such decisions and on what basis, with a view to recovering some of the monies of the SABC that was irregularly paid out to individuals.
Right, just from where I'm sitting, I agree. Bonus and lack of performance management systems. The question that I'm asking, and it's a technical one, is there no performance management systems, or was it lack of compliance with the performance management system? Do people know that? Lack of compliance with the system. Is that okay? Eh? Yes, I'm just asking the question. I'm not even sure, are we saying there was no performance management system, or are we saying there was a performance management system that was not complied with?
Well, Chair,
yes,
if I may, the paragraph says, the testimony from the Human Resources Group Executive revealed that the SABC did not have a performance management system. Didn't have one at all. So it wasn't as if it wasn't adhered to.
I'm just saying that we will do that double checking. If maybe we've miscaptured it here, you'll be happy with compliance. If it is accurate here, we'll leave it as it is. Okay. Now, these chaps next to me are very sharp. They're saying that the audit committee approved the system, but it was not implemented. So what does it mean in technical language? There was a system, isn't it? It was bypassed, but I'm saying, you see this thing, so this thing is very wrong that says there was no system. That's why I'm saying, if we're creating the impression that there was no system, we might not be 100% accurate. We should be rather saying there was a system that was approved, duly so, and not implemented and therefore not complied with. Baba.
Yes, Chair, I think it should be so because you can't have a group executive, human resources saying there was no system. I mean, performance system, because at the end of the day, he or she could be the custodian of the very same policy, the performance management system. So there was a system, but it's only that it was not complied with.
We'll elaborate a bit further on it. In other words, we'll strengthen that sentence so that there's no ambiguity. There was a system approved, it was not implemented, and therefore, by virtue of not having been implemented, it will have been flouted. So we'll strengthen that sentence to reflect all those accuracies. Can we move on to 9.1? Yes? Okay. 9.11, any comments? Nine point 1.2? 9.13? 9.13? Yes, Honorable Motsoeneng and then Honorable Van Dam.
No, I think we must mention that, I think it must definitely be mentioned that the editorial responsibility was then transferred to the COO's office. I think that's quite key because
the 9.13, or you're saying it must be a new paragraph, sir? I'm trying to see where will it fit into 9.13. You want to speak to that one? Okay.
I think it needs to be a bullet point on its own because it speaks to the approval of a revised editorial policy. And one of the things that it did was make the COO the editor-in-chief. That information is public record and also was part of the SABC 8 testimony. I think it's very important that we include that, and I think it's a bullet point on its own. It's a clause on its own. I'll write it. Yeah.
Okay. 9.15 will be crafted. Nine one three. Van Dam and, I beg your pardon, Killian and then Loliwe.
Chairperson, can I just ask, we have refrained from using sort of descriptive language such as chilling and disconcert or serious. I think it's just misplaced here. Could we remove that? Yeah, or scaring or whatever.
Chair, I was a bit overtaken because I wanted to come immediately after Honorable Van Dam to say, her new point, let it rather be a new 9.1.4. And then the current 9.1.4 becomes a 5.
All right. Van Dam's suggestion that she will table tomorrow will be 914. So can we then move on to 914 as it stands here, but it will become the new 915? Any comments? All good. Thank you. 921. Honorable Singh,
Chair,
and then Motsoeneng.
On 914, it's unabatedly, yeah? So just the last word. The last word is unabatedly. On this one, regulatory compliance, what is it we are doing? Just making a statement about what regulatory compliance is and expressing a view. How is it linked to testimony? I'm asking, because I was not there.
I think ICASA in their presentation referred to it, maybe not as we put it here, but I think ICASA, remember ICASA spoke about the minimum standards in terms of local content and all that. I'm sure ICASA. Okay. I mean, the point that is being made is that it came from ICASA. It might not be as we put it there, but it was an ICASA input. It was Mokoena and then you, Swarts.
The case that was opened against the SABC by CASA, where does it lie in 9 point whatever or 9.1 or 9.2?
No, there was definitely a case they spoke about of R1 million somewhere. I don't know if you're asking where should we fit it in or is it there at all?
That's what I'm asking, yeah.
All right. There's the point about the court action between ICASA and the SABC. We can make it a standalone if we wanted to.
Chair, that's what that paragraph is introducing.
Which one?
The 9.2.1.
Oh.
And it sets out the complaints directorate, and then obviously 9.2.2 must be amended because in terms of the complaints compliance on the 11th of July 2016, ICASA then directed the SABC to withdraw that resolution, and that was the evidence that was tendered. And then ICASA said, as to date, they have not got evidence that that resolution was withdrawn. And in fact, as at the date of the evidence, they have indicated that they have laid criminal charges. And that's the evidence. We can obviously make an observation that it seems regrettable that that order of ICASA was not complied with, resulting in the laying of criminal charges. But that clause needs to be amended, and I think I can do that quite easily if you want.
You're saying you'll take 9.2.2 and include the specifics you're talking about there?
Yes.
Will you be happy with that, Mr. Mokoena? Yes. You will. We're still talking to 9.21 at this point. Or let's talk to 9.21 and 9.22 because they seem to be interrelated. Mr. Singh and then Ms. Killian.
Thank you, Chair. I don't know if this falls in here because I got what ICASA presented to us. And one of the questions that they were asked is, from their information, who took the decision on the 90-10 issue? And the answer was they don't know how the decision was reached. Now, I think later on, I'm going to recommend, I think all of us are on that point about the 90-10 policy and its continuance and moratorium amendments, etc. We need to bring in something about it here under regulatory because ICASA also said to us, the SABC has a public broadcasting service mandate with associated extensive universal service obligations, including obligation to provide coverage to 100% and then obligation to cater for minority groups, children, women, and people with disabilities. That's what they presented to us in testimony. And I think we don't have that testimony here, that they don't know how that decision was reached. It could have been ultra vires, and that's something that we're going to talk about later on.
Chairperson, yes, I would like to support that because evidence was led about not only the news editorial policy and changes to that and whether the process was proper, etc., but also as far as the local, the content policy, music content policy. So I would suggest that we bring in an extra paragraph, but if I could just go back to 9.21, it's not a major matter. I just wanted to make sure that we do it in terms of the Act. Reference at the bottom, Chair, is the last reference is to Section 17E2B and BC. Now, if you look at the Act, I would suggest, because it is quoted here, from 17E, a decision by the authority, and sub 2, so 17E2 in its entirety is actually sort of almost quoted. So I would suggest that we say, we start in the middle where the sentence starts the Act, then we make it a new paragraph to say the Act in section 17E2 empowers the Complaints and Compliance Committee to direct the licensee to desist, etc. to direct the licensee to take such remedial or other steps in conflict with the Act or underlying statutes as may be recommended by the Complaints and Compliance Committee, full stop, or by the CCC. So if we do that, then our reference to the Act is just correct.
Can argue with that. It strengthens the document. 922. Was that the point you raised? Yes, ma'am? Oh, is that the point you raised that you said you'll strengthen or something? What did we say on that point?
That's the point I wanted to include with a little bit more detail. So instead of including an extra clause, perhaps I could just add to that.
You'll come with a suggestion. All right? Note that. You're not sleeping tonight, Van Dam. 1011. Any comments on 1011? Yes, sir.
I think we must have a preamble that says that the contract for the multi-choice was supplied to the committee, albeit that it was blacked out in some things, so it was incoherent. To say that I think we need a preamble to say that the contract for the multi-choice SABC transaction was provided to the committee, except that it was blocked out in some parts and was therefore incoherent. And then, that will then explain the holes that we then go into in the following paragraphs.
I'm trying to, from how we're going to put it in there. Is it a preamble or can we add it to 9.11 or do you want it as a standalone?
No, in 10.
I beg your pardon.
Yeah, in 10, so it becomes 10.1.
Or 10.11 and then whatever is 1 becomes 1, 2 and 1, 3.
That's correct, yeah.
And you're saying what should we do there? That the contract was supplied but it was not complete?
It was not coherent as it was blacked out in some parts. Because I think it's important that we mention that that we were given a contract, but it didn't help us with anything.
Were we given a contract?
Didn't they give us a contract?
No.
No, they did with. No, they gave us a package with. Did they not give us a package and there was a contract that was blacked out?
No, no. If you find it, I'm looking here, we'll look for it, but if you have that contract, because we must be able to substantiate it if we put it in here. But Honorable Kubisi?
Yeah.
Chairperson,
we did get it.
I would have loved to see perhaps a sentence that says SABC entered into a deal with the multi-choice, and of course the year and the month being mentioned, and say in one sentence stating what the deal was all about. I think that will sort of give a preamble to the deal as such. You know, what this deal was about, which year was it? For a person who will be reading this document years and years to come, so just to have that.
Well, first of all, what you're asking for Honorable Kubisa will depend on if we've got this contract before us. Because I don't think it's as simple as a one-liner, because I think it spoke about the news channel, it spoke about the archives to a certain extent, and I think it was even linked to the encryptment and non-encryptment. So I don't think you can put it in one sentence. So, and that is why we thought that we will just refer to this deal. Because further on, we asked for this deal to be subjected to a forensic audit. That's what we say further on. So I think in the front we should just be saying this deal didn't sit well with us in whatever words we put, because once we elaborate, we almost preempt the outcome of a forensic audit. I'm just saying let's be careful about not shooting ourselves or anybody else in the foot. Let's take Killian, and we will take Motsoeneng, and then we'll take Swartz. Oh, I beg your pardon. Before you, Killian.
Okay, no, it's fine. You can come in again. Come later.
Killian, Motsoeneng, Swartz, and then Chauke.
You see, Chairperson, I'm a little concerned because officially we have not received the multi-choice transaction. It was listed per communication dated 6 December from Mr. Lucky Takiso that these documents will not be provided on the basis of privilege and because the disclosure may negatively impact on the SABC's commercial interests. So I just wanted to say that if we got it, now remember, some of the institutions told us that it is on a website. We can download it from there. Now, clearly, that's different. So we never got it, but I think it's important that we list suspicious transactions. And I would also like to suggest that we term them transactions as a heading. But I do believe that we never officially got that. And it's important that, that we differentiate between those documents that were officially presented to us and the others that were not presented to us. I would also like to suggest that we make, in support of what Professor Kabisa has said, we could, by way of introduction, refer to the minutes of the board meeting of the 23rd of July 2012, where the multi-choice transaction was discussed and for which we have minutes. And then we have a set of minutes of the 12th of June 2013, a very brief set of minutes, where again, it's basically just a 2-page document, where multi-choice was again as a special meeting of the SABC board. Now, clearly, in the end, we can also refer, but we need evidence of that, to who did the person who signed off on behalf of the SABC have formal board approval to do that? Because I think that becomes very important. If we want to have further investigations and a forensic audit done, it is our concern. We couldn't do everything within the very limited time at our disposal, but clearly this is giving us reason to believe that this is a suspicious transaction. So I would support the introductory paragraph, and if necessary, I'm prepared to assist with the formulation of that.
All right, members can consider that. I'm just thinking, this one we're not even disputing. We all know that we're calling for a forensic. So should we be specific? We should be saying there's a problem, go and investigate. And in our in our observations and recommendations, we can allude to the fact that even those board minutes that we've received, Killian, have not been authenticated or whatever the case might be. So I'm just saying, for me, it would be, there was something that worried us. We don't have the ability to come to a conclusive recommendation because of our lack of capacity. Can somebody with the requisite capacity go and look at it? I think that is how I'm saying we should present it. I just don't want us to be seen to be having a position one way or the other, or influencing it. That's my own, not as a drafter, that's just my own position. You've heard Killian's, you've heard mine. Can we take Motsoeneng, can we take Swartz, and we can take Chauke?
No, Chair, I agree on the details of what you just said now. But we did receive a contract. Dr. Koza's just checking, because she agrees as well that we received it. I'll check on my things as well, just to make sure. Which would mean that we should probably park the discussion around the preamble that I was talking about. And then we can entertain it when,
Chair, I don't like the word deal. I think we need to be more elegant and refer to an agreement or a contract. And then we need to also be fair. The minister did give us an explanation. So we've got to, how do you strike the right balance where the minister gave an explanation? She indicated that this matter had been cleared by the Portfolio Committee on Communications and by ICASA. So we might need to just make that statement. The minister gave an explanation on the multi-choice relating to this. However, questions still remain, something along those lines, because I think it's important. There's a lot of issues we are raising where we did get some explanations, and the challenge is to what degree do we include those explanations. We don't have to accept those explanations necessarily, but in all fairness, you need to also indicate that there were other views expressed. The minister was quite surprised that that issue came to us at all. That's what she said in her statement. I don't say we necessarily have to accept that, but we need to just portray that in fairness. Thank you, Chair.
Absolutely correct. And then after Mr. Chauke.
No, I think the matter has been closed, Chair. On our side, I think if you recall that we have not engaged in detail on it. All the time we've been flagging it. And I think how you close it will be to note the input made by relevant inputs that we have received during the submissions of evidence, and then make a closure on that with the point that calls for what we have sort of recommended at the end. We don't have to go detailed here. I think it's a small matter, but that require further probing moving forward. I think that's how we flagged it from the last time, and then I think we can just bring it to life through that process.
Happiness? Okay, let us try and clean it up as best as possible. Again, we'll revisit it on the 24th before any document becomes an official document. But I mean, we note the points, and it's not official until it's adopted on the 24th. 10.1.2. 10.1.2. Ms. Killian.
Chairperson, I think we must just correct in line 2. It's not the interim board that was appointed. It was well underway by the time that the board was appointed. And then we can go back to the interim board. It's just that reference to interim board there, I think, is perhaps not correct. Unfortunately, there was an interim board which lasted for 6 months, and then thereafter there was the appointed board consisting of all 12 members. We must just differentiate. If we say it is a foregone conclusion that the multi-choice agreement with the SABC was well underway by the time, I think we should be correct to say it by the time the board of 2013 was appointed.
On 10.1.2? No.
Just the last sentence doesn't read correct.
No, that's grammatical. We'll pick it up. Is that what you're talking about?
No, it's just, okay.
Yeah?
It's just a duplication, but we can correct that.
No,
later.
that one we'll correct, yeah. 10.1.3? 10.1.3. Happiness?
So that was one member. A board member's raised...
10.1.3.
10.1.3. No,
Yes?
that's fine. Board members raised concerns. But it was Mr. Krishnaidu in particular. Other members raised concerns. You see, and Mr. Krishnaidu provided a legal opinion. Then 10.1.4, in
No,
light of the-
10.1.3, sir. That's where we're at, isn't it? We're saying board members. Is that inaccurate?
No, board members, comma, in particular, Mr. Krish Naidu, if we want to mention names, comma. Because he was the one that, as a lawyer, gave a legal opinion.
Can we perhaps settle for some board
Some,
members?
that's fine. And then 10.1.4 needs clarification then.
Okay, and first 10.1.3, you're happy if we say some board members?
Yes, and it's not a deal, it's an agreement.
Yeah, we'll change deal to agreement. 10.1.3, you got that? Okay, then we move to 10.1.4. Let's then take Swartz and we'll come back to you, Killian.
In the light of the above, the then chairman proposed that a second legal opinion be obtained, which ultimately contradicted a board member's legal opinion, because it was Mr. Krish Naidu's legal opinion. The board, in his statement, he says, I advised the board that the contract was unlawful and submitted reasons for arriving at this conclusion. The chairperson suggested that the board obtain a second opinion, which was subsequently done and which contradicted my opinion. So there wasn't board members' opinions, legal opinions, which ultimately contracted a board member's legal opinion. The name.
Also wanted to make a suggestion. Sorry.
Do you put the names in? Why not we put his name, Mr. Krish Naidu? Let's put it there.
Chair, I just first want to go back to the caption as it is, where it is saying a second opinion, which ultimately contradicted the board member's opinion. It is the second opinion which contradicted the view of board members. So I think that caption is correct. We are in 10.1.4. Honorable Swartz was proposing that let us not say contradicted the board members' opinions. He was saying let us make it an individual board member's opinion. I'm saying it was the legal opinion which contradicted the views of board members. So to me, the caption is correct.
I agree, Chair. Or you can say certain board members' opinions. Certain, because there were some that agreed and some didn't. So that's fine.
Now, before you come in, what we're all in agreement with is that there was more than one board member that differed. At least Rachel Kalidas and at least Krish Naidu. At least those two. That's why I'm saying some board members is a more accurate representation. And that we have as evidence, not even in writing, that is evidence that was presented before us. And it was not just one board member. And really, we can add it, we cannot add it, it doesn't make a difference. But what do you want to say, ma'am?
Chairperson, I was wondering if we can just start it with a little extra sentence at the top. I mean, introducing the following sentence just before we move to in the light of the above. 10.1.4, one of the former board members, a practicing attorney, assessed the contract and advised the board that it was possibly invalid. And then we continue to say, in light of the above, the then chairperson of the board proposed that a second opinion, which ultimately contradicted the board member's opinion, be sought.
Happy. Any comments? 10.1.5, Mr. Singh.
Chairperson, yeah, that first sentence, not grammar, but there's something missing.
The committee.
Yeah. Per testimony heard, comma, the contract was purportedly an agreement whereby Multichoice would use the SABC's archive material on condition that a particular position on setup control. We were told there was some reciprocal arrangement, but there's some words missing there.
It's easy, was adopted, 2 words. That a particular position on setup control was adopted. But, Chair, am I on the floor now? Sorry.
Yeah, I think he's making a good suggestion, but we're going to him now.
The beginning, per testimony heard, we need to say according, like we've said consistently, according to the evidence, comma, the contract. Then I was adopted, and then that sentence, this condition rendered the contract unlawful. We can't make that statement. On what basis in law can we say that? We could say it appears or it could be, but we are stating it as a fact that that contract is unlawful. So we take it out. There are questions. Secondly, the person who signed off on the agreement was not authorized. Do we know that as a fact? Or we should say maybe it appears that the person who signed off. Do we know that unless we know it as a fact?
We can check it, but I'm saying for the whispers and according to witnesses' testimony.
Again, then say that, yeah.
Okay. Yeah, according to witnesses' testimony, it was not signed off by the duly authorized individual. That will cover us. Is that all right, Mr. Swartz?
Yes.
All right.
And then 10 point, if we're happy with that, 10.1.6
No, we're not happy with that. Are there other members that want to talk to 10.1.5? Anybody else? No. All right. 10.1.6, you'll be the first one, Mr. Swartz.
There were other defects too. That sentence is not elegant. Surely, if there are defects, we must put them in the one paragraph. What relevance has that got to whether the contract should be entered into? There were other defects too. In other words, in the contract, the downturn in the economy meant that what is that? What is the relevance of that to the contract? The debate. There were also other issues concerning what? Many of these issues were addressed with some success. There's no relevance to that, to the contract. It can be put somewhere as to the financial standing of the SABC. There's relevance to that there, but not here. So let's just park it somewhere. You see, Chair. No, just hang on a minute, because the next paragraph then says, it goes back to the contract, you see. So I still, 10.1.7 goes back to the contract now. I still hold to the firm view that that is not really relevant unless you sketch in.
It's not relevant, 10.1.6.
10.1.6.
Yeah, but we're saying we're deleting it. It doesn't arise anymore.
Okay.
10.1.7, is there any comments?
Now we go back to the agreement.
Chairperson, I would suggest that the first part of 10.1.7 is fine as it is because it links onto the person who signed off on the agreement and, evidence before the committee. Then it says, given this context and considering that as of the end of so-and-so and so, it is clear that a significant section of the country's population has no access to DSTV and therefore no access to 2 channels of the public broadcaster, namely so-and-so. This is particularly problematic. Chairperson, I think the point that we're trying to make here is the fact that we are excluding the public from viewing SABC material because of the agreement with a pay channel. And I think that's the essence of what we want to capture there.
The boss is suggesting that should in fact be better placed as an observation. Whole 1017 goes to observations. All right? But then, I don't know, my one says, oh, okay. Yeah, okay, all right, mine just had a gap. So we're saying the whole 1017 becomes an observation? 1018?
And why do people not have access to SABC News? It says they have no access to 2 channels of the public broadcast. SABC News, they've got access to SABC News.
No.
24-hour SABC
404, yes, it's SABC News. And we're talking about DSTV. But the sentence before says, because we have no access to DSTV. Or do you want to say channel 404? I'm saying...
No, I think we must say SABC News Channel.
Is that what it is?
Yeah. Because I think that's what's confusing. He's thinking it's SABC News.
Okay, the official name is SABC News 24. We'll say people don't have access to SABC News 24. Would that satisfy the committee? 1018, any comments?
Sorry, Chair. May I speak? I do believe that we could probably move this paragraph also to the observations. If we move the other paragraph, then it makes sense that it goes with.
We can do that. Although documents presented to us in the guise of the Public Broadcasting Act says that, so we could have it both places. I mean, remember, we're taking observations, both written, oral, and documentation. I agree that it could be in the observations, but it's certainly part of the body of the document. It was part of the documents presented before us. That is a direct translation from Section 8J that says libraries must be maintained and established, or established and maintained. Can we have them in both? Yes? Thank you. 1019.
Just briefly, there's the second sentence, per the former. What is that? Let's just stick to according to the testimony of the former company secretary, comma. And then the next before that, confidence. The first line, the committee could not establish with confidence, with certainty. That's probably better. And then the very last sentence, certainty. The last sentence, this contradicts most testimonies. This contradicts other testimony. Not most, say other testimony. Or most other testimony. Most other testimony. Thank you.
To venture any strengthening of that paragraph? No?
Sorry, check.
Yes, sir?
Should we name the company secretary? No?
Well, to be consistent, you said we must name everybody else, then we must name the company secretary, so that in your argument that it wouldn't be somebody before, somebody afterwards, consistent to the decision, we'll name the company secretary, the then company secretary anyway. 1021.
Hey, I think we're too similar here, Steve. Hey.
Sorry, I apologize, sir.
No problem, no problem. No. Chair, here, I think we're referring to the affidavit by, is it Lamini? The lady. But I think where we read about 800 newspapers, etc. But the other very, very important testimony with regards to, and I'm seeing New Age there, was a TNA. And nowhere in our document, I've gone right through to the end, except for in our parliamentary oversight section on page 36, have we made reference to TNA and what needs to be done. But I think in testimony, a lot was said about TNA by former board chairpersons. And we've got to bring that in here as testimony somewhere and include this part about the newspaper. Because the TNA thing was, for us is a quote-unquote suspicious, Honorable Swart, arrangement. Not suspicious deal, but a suspicious arrangement. And there was evidence about 16 broadcasts, film Malifa, etc., etc., and the business sense that it made. So I think we've somehow omitted to bring in that testimony, because it's going to be very important to tie the testimony up with our submissions, our recommendations.
Chair, just to do with the corporate executive technology, we're going to name that person as per the agreement. But on the second line, where we say that this person had a meeting between himself and a representative of the New Age Media group, we need to name that representative. It was mentioned during evidence, Mr. Williams, I believe, and the date that that meeting took place. I think it's important that we have it in the report. The individuals that were met and what date it was. Thanks.
I think practically the first paragraph should be that testimony was given. No, I think yeah, the first paragraph should read, testimony was given by Phil Molefe that the New Age Media agreement was initiated by the COO in conjunction with the then chairperson Ben Ngubane. In contradiction, Ben Ngubane then says that the contract was initiated by Phil Molefe himself, citing that there were 16 broadcasts. Yeah, I think we should preamble it in that way and then go into the. That becomes the first one, yes. Yeah. That's correct. Yeah, yeah.
Phil Molefe comes to the committee and he says it was initiated by, you said the C?
By the COO.
The COO.
In conjunction with
with Ben Ngubane.
That's correct.
Later on, Ben Ngubane comes and says it was initiated by Phil Molefe through a 16 pilot thing. You want us to put that paragraph in first?
Yeah, I think let's put it there. Yeah, because I think we must also investigate who lied.
No, it's fine, absolutely. So members are saying that should be the first paragraph? Happiness?
Yeah.
All right, if that is, you've confused me. Then 10.2.1 as it stands here now, we are happy with it. 10.2.1 as it stands. Can we take Swartz and then take Singh? 10.2.1 as it stands here.
Mr. Singh, I think referred to, who did you say that? Is this not, we're referring to Masinga here? That is the name that must be inserted, because I just wanted clarity on that. Was it? Because there was firstly the rebranding of SABC News. That was one meeting. Then there was the sale of the newspapers. That was a separate. We're dealing here with Mr. Masinga.
Yeah. That's why we had an opening paragraph that deals with a different topic about contradictory evidence. The second one, 10.2.1, will then say Mr. Masinga as opposed to the corporate executive. Are we understanding it correctly?
Yeah, Chair, I want to suggest that we have a separate heading on TNA breakfast shows, or whatever you call it, TNA breakfast. And because there was a lot said about it, and we shouldn't just confuse it with New Age Media. The media is just about buying the 800 newspapers. But we should have a separate heading and a couple of paragraphs on the TNA.
No, I'm saying remember we're looking at this document first. Is the TNA breakfast referred here, or are you saying it's an addition that we must put in? Okay, so then can we do 10, up to 10.2.3, and then you introduce that introduction, because all these presumably talk about the media, isn't it? Yeah. All right, but we'll take that point of yours once we're done with 10.2.3, which will probably become 10.2.4 after the introduction. I'm going back to 10.2.1 as it stands. Can we tick it?
Chair, just quickly, Mr. Waterson referred to a name earlier, the meeting, the AN7 name. I'm not sure if that's the correct, because Mr. Masinga met with Nazim Hawa, according to his testimony. So we just need to make sure we're referring to the right people, if I'm correct. Thank you.
Happiness, Mr. Singh? I mean, Mr. Waters? Yeah. It's fine. All right. Anybody else on 10.2.1? Mr. Motsoeneng?
So
10.2.1?
Yeah.
And then you'll be following up by Prof.
So if we're going with the new 10.2.1, I think this one then must start off by saying that the then corporate executive, and then we name him, also confirmed that the new age media agreement was initiated by the COO, and then we continue with the rest of the. Because he said that it was the.
You want to put the COO?
No, because in the new 10.2.1, remember we said Phil said this, and then Ben Ngubane said the other thing. But in this one, we then have to say, but this one also mentioned that the deal was initiated by the COO.
Did he say that? That's the question they're asking.
That's what he did say, yes. He said, remember he said that that they met and he had given him like a 2-pager or a 3-pager.
Okay. No, I'm saying we'll do the homework. So, and
okay.
if it did was also initiated by, we'll add that.
Yeah.
Can we do that, Cindy? All right. 10.2.1. Anybody else?
Yeah, Chair.
Oh, sorry, it was.
Yeah, no, I think another important point which came from Dr. Ngubane was that this TNA SABC partnership or pilot had to run for 16 times without any contract signed. So I think that point is important because it somehow speaks to how procurement or supply chain management rules were violated in one way or the other.
We'll capture that in what is now the introductory statement, our introductory paragraph. Ngiyayvala 10.2.1, madod and ladies. Can I close 10.2.1 now? 10.2.2. 2.
Chair, oh, sorry.
Swartz, 10.2.2, Swartz, and then Van Dam. Yes, Swartz?
Firstly, this is inquisitorial, it's not adversary, so we don't have to prove beyond doubt. So could not establish with certainty, I would say. But we need an introductory something, because suddenly this issue about the New Age newspaper, the only information I could find was the Dlamini written submission that referred on page 8 to her receiving a call with Mr. Motsoeneng about this issue and the meeting that was then with TNA Media. So we need to just have some introduction because it's separate to the other issue. That as firstly an issue of the distribution of that newspaper, plus whether it is still the norm today. And that it might appear elsewhere, and that's why I'm asking Cindy if it's anywhere else, but it's Dlamini that refers in her written submission that we got last night.
So what is the proposal you're making, sir?
That we need to rephrase that slightly, just to introduce this as a separate issue about the distribution of that newspaper. All that it says in its present state is whether it is continuing. So the statement there is whether it is still the norm, and we need to say, but what was the agreement. What was the meeting? What was it about? We need to just have something there. I'll draft something. 12 o'clock tonight sometime.
Fine. I forget, was there anybody else around? Van Damme, I beg your pardon. Yes, ma'am?
Chair, I don't know where it comes from that we couldn't establish it beyond reasonable doubt. I mean, I've got a reply to a parliamentary question from the Minister of Communications where she confirms that they're still buying Gupta newspapers and their support has in fact tripled since 2011. They've tripled the amount of papers they're buying. So I don't think this paragraph is correct because we've got the information that says they've been buying newspapers since 2011 and they continue to do so.
You suggesting we take this in?
Yeah.
That's another proposal. Honorable Oliver?
Thanks, Chair. Chair, I think what we are articulating here is what witnesses said. Then as a committee, out of the testimony given, we could not establish whether the sale of New Age is, the distribution of the New Age is continuing or not. We are not saying as Parliament, just as this committee, according to evidence given to us.
No. We had fixed up the beyond reasonable doubt. Remember, we said with certainty. Remember, the first submission made was the committee could not establish with certainty, and then we made all those amendments. You are saying that you have in your post, not you, I suppose, Parliament, South Africa, by way of a response from the Minister. There is some sort of, so we need to marry what we got as evidence and what we know. I think that's what we're grappling with. You want to help us?
So therefore we can't then say without certainty, because we can with certainty. So we can say during testimonies it was not clear whether or not the distribution was still happening. However, we have information tabled in Parliament that it is still continuing.
It was not clear, it was not confirmed.
Not confirmed, something like that, yeah. Am I right?
No, Chair, I don't know. I think we must just leave it. And then it must go into the recommendations, right? Yeah, I think take that totally and then we'll put it in the recommendations to say, no, not in observations, in recommendations. We'll then say that it must be established whether this, this thing is there or not. And then...
that we take 1022 out. There's another proposal that we take out the words with beyond reasonable doubt, or no, beyond doubt. And I'm not sure, Mr. Swartz, anymore, what was your proposal? What are we going with? Which one are we going with, the three of us? Take it out, not the three of us.
No, because the thing is, there's no evidence to whether it's still there or not.
So we take it out?
Yeah, I think let's take it out. That's my thinking. Because we're dealing with evidence here. We're dealing with what was given to us. And there was no one who testified to us as to whether the thing is still going on or not. But I think then when we deal with recommendations, we can then say it must be established whether this thing is still going on or not.
Fine. Not Swartz, Singh and then Van Damme.
Chair, thank you very much. On that, I think there was a specific response by Dr. Ngubane, because I asked him the question about this 800 newspapers. Did you think it was reasonable? And he said, well, he doesn't think that it's still being done. But we could not establish whether these 800 newspapers were still being bought or not being bought. 800. Because the evidence of the Lamini, Ms. Lamini said 800. She was forced to buy 800 newspapers. So he really confirmed that he didn't think that that was the norm now, because I asked him about other publications. What about other publications? Why didn't you buy other publications? So that's my point on the newspapers. I think it's important that we have the newspaper thing there because it was evidence.
I don't think we can take that paragraph out. It is very, very important because it speaks to the questionable deals that happened with Gupta companies. I don't think we can take it out. We can reword it, but it's certainly important to include it. And also to include Mr. Mvoko's testimony about Morning Live resources being used and how that was an effective laundering of money, SABC money to the Guptas. I think we can't take it out. It's very important.
Now, I'll suggest that we leave it if we're going to make a recommendation on it. The way it is currently, I think we can just leave it as it is. Because when we deal with the recommendation, there must be a base in which we draw a recommendation from. So just leave it as it is, and then we'll deal with the detail in the recommendation.
Okay. Before you come in, Mr. Swartz, we could also, and I'm saying we could deal it and we can look at it. I mean, what we do know is Lamini gave evidence, whether it was in writing, spoke about it. Ngubane gave evidence, whether in writing or oral, spoke about it. So we can say evidence received from Ngubane and Lamini referred to the newspaper distribution or the newspaper sale. I mean, that's evidence, that's facts. We then can go and then say, this is what we observe and this is what we recommend. So I'm siding with those that says it must be there. We can shore it up slightly by saying who exactly gave us that evidence. And then we revisit it in the observations and we revisit it in the recommendations. Would that suffice? Thank you. You still want to talk to the same point?
One brief sentence, and that is Mr. Lamini says the newspaper is still in circulation even today. And that's the date of her statement, which is in January.
No. That's what I'm saying. We will just say that evidence was led to that effect. I mean, evidence was led to whatever about the newspapers. That's factual. Mr. Both Ngubane and so spoke about the newspaper, and then we go and say whether it was confirmed or not confirmed, or Dlamini confirmed it in our recommendations. Would that suffice? All right. If you don't like it on the 24th, we can further tighten it. 10-3. 10-3. Is that not an observation? Can we just take it and put it into observations opposed to arguing the grammar and whatever? It's an observation, isn't it? Eh?
It's obvious. So it's an observation.
Okay, then whatever comes between 10-3 and 10-3-1 is now specific topic around the breakfast shows. What is it that you want us to add, sir?
Well, Chair, I think firstly, they spoke about Vuyo, what he said about it, what Dr. Ngubane said about it, the Phil Malifa thing, the 16 shows, etc., etc. I think that evidence, that testimony must be included in quite a bit of detail from the different people.
So I'm saying from whatever we got, we'll have to make a point about Vuyo's evidence, a point about Phil's evidence, and a point about Dr. Ngubane's evidence as having been heard at this committee. So we'll add those three there. Then we'll get to observations and recommendations later. Would that suffice? You got that? On the same point, Mr. Mokoena? A different one. Okay, so then can we go to what is now 10-3-1 and talk to 10-3-1, Mr. Mokoena?
Okay, so I think 10-3-1 must be a different thing completely. I keep harping on vision view, but I think we must give it a bit more meat now. 10-3-1. In 10-3. Instead of going, because we've been going on these, because I think it's part of the agreements that were irregular and that's correct, yeah. And so I think let's give it attention before we go to digital to DTT. We give more of a meaty insert on sorry?
Just say that again?
No, the vision view thing.
Oh, the vision view thing.
Yeah.
So you want vision view as a standalone?
As a standalone heading.
What heading do you suggest we give it?
Vision
Yes.
view. Vision view.
Oh.
Vision view, yeah.
You want to give it a heading called vision view?
Yeah, so that we then discuss the fact that it was procured irregularly, one, that 42 million rands was spent on it, and it's not we're not sure why, and that vision view is still continuing, and we don't know what the relationship is between them and the SABC. So that when we go to recommendations, we can then recommend that it must be investigated as well.
Pardon. Can we then go to 1031 as it stands here? But of course the headings, I mean the numbering will change. 1031. Are we moving? 1032. 1033.
Just a bit of wording there. The second sentence, it can further be insinuated. I think one should rather be more oblique and just say, it appears. The second line of 1033, where it starts, it can further be insinuated. I should, lawyers are more diplomatic. It appears instead of can further be insinuated. Yeah.
The boss is suggesting that would 1033 not fit better under observations? Or both, or where? 1033, observations? Observations? All right, thank you. So 1033 will move to observations. Then we go to, in the last half an hour, we can, yeah. No, tonight we'll finish everything and we'll start with observations if necessary. We've got a few pages left. Let's go to this 1111, the old or the existing 1111. Any comments? No? Names? But yeah, we had agreed that we will put names in there. Mr. Singh and then Ms. Killian. 1011, I mean 1111.
Yeah, Chair, if I just look at this now and anybody else, it says response to the report, and then it gives a narrative. Now, whose response to the report? You know, one would think that it's our response to the report, the committee's response. We can either say response to the report by board members and the HRC. What was it, the HRC? Human Resource Committee. Because in the narrative, those are the two entities we refer to. But I just think response to the report on its own, like that highlighted, can be a bit misleading. Yeah, in our report 1113, we say the Human Resource Committee had recommended that disciplinary proceedings be instituted against the then acting CEO. Now, I don't know where that evidence came from. Okay. It's a response by the board to the PP.
Or amendments or comment, 11.1.1. Yes, Ms. Killian.
Chairperson, just the first sentence. Board members gave evidence that the Public Protector's interim report, which the then chairperson had received in December 2013, was never tabled in the board, SABC board, or any of its committees. Sorry. Right. Board members led evidence and confirmed that the former board members, sorry, confirmed that the Public Protector's interim report, which the then chairperson had received in December 2013, was never tabled in the board or any of its subcommittees.
Okay. Yeah, we'll say that. Remember, that's the principle that we've adopted earlier on. Okay, 11.1.2. Honourable Waters.
Thanks, Chair. On the next page, it says that consensus could not be reached as to how to respond to remedial action contained in the report. Some board members thought that they should be implemented while others disagreed. If you remember when Mr. Shabalala was here, Honourable Van Dam quoted minutes from the board meeting which stipulated that they actually had agreed to implement the actions of the Public Protector. Yeah, and so therefore that sentence is false. There's minutes of the board.
It's the 18th of March, 2014. And I'll forward this to you. And the resolution reads, the board submits a letter to the DOC to explain the process that the board was following in dealing with the Public Protector's report, together with the timelines to complete the implementation of the recommendations. And those minutes, there isn't any indication of discord. From these minutes, it appears that everyone agreed that...
Let me play devil's advocate. You're reading there that says, according to the minutes, there was whatever about action taken. That's what the minutes are saying if you read it verbatim. But that doesn't say that the action taken was unanimously adopted one way or the other. Because, I mean, I remember somewhere, and I think it was what even brought about the employment of Nkunu lawyers, if you recall. There was, and also, if memory serves me correctly, and we'll check it, some board members felt that that it must be implemented holus bolus. Others said, no, let's get the lawyers, and then it went through to subcommittees. So I think there was a bit of discontent. And that's why it even eventually went to a point of whether they're going to take it on review or not. So I'm saying those minutes, as you read them there, you're correct. The minute says there was a decision taken. But, and maybe if you're saying there was a board decision taken by vote or something, but and we can say there was a decision taken, but I do know that there was evidence in terms of difference in interpretation of the implementation of that decision. So we could put both of them in if we want to, because that was what the evidence led. And it's what brought the schism in the board at some point. There were those that wanted it implemented and those that didn't want it implemented. So I'm saying that is, as I understand it, how we actually crafted here is what must reflect what we got from evidence. That's all I'm saying. So that is probably one source, but there were other sources. And I'm just saying let's take all the sources, but let's hear you, Ms. Van Dam.
From these minutes, it's not conclusive whether or not there was discord. It's not mentioned at all in the minutes. So can we say it would appear that from the minutes of the 18th of March that the board unanimously, yeah, it would appear because there's no mention, I mean, we have to base it on the facts, and the facts in front of us don't mention that board members were in disagreement about whether or not the recommendations must be implemented. In fact, the minister at the time, which was Minister Karim, it says here, the minister mentioned that the DOC was of the view that whether the recommendations and the allegations about individuals had been correct or not, the allegations had been made in the report so were substantially similar to the SIU's report in terms of the trends and previous reports. So an analysis of that statement would say that the minister agreed with the findings of the report because they were similar to the SIU reports.
Can I try and summarize it and put it in words? There was a decision in the board, as per you saying, to implement. There was evidence to the effect that the how was, there was divisions as to the how, and then this uncertainty was further fueled by the public debate about the nature of the remedial action. So we could put it into 3 bullet points in trying to, so there was a view to implement per the board minutes. There was evidence to the effect that there was some disagreement as to how, and then there was a debate about whether we should take it on review or not. I mean, those were the kind of things. Whether they did take it eventually, because that's what they said. They didn't take it, but I'm saying those were the discussions at the time. And I'm saying that all came out of the minutes. And we can do it that way, because maybe we were trying to be clever and put them all in one, but if it means we must put them point by point so that we can list the events, we can do that. Maybe we were trying to be too clever and can put them into one. Oh yeah, you can say something, and then Motsoeneng can say something, but let me warn you, the one that has the most convincing argument is going to draft the paragraph for us. Carry on, I'm kidding.
Okay, just to also assist us in deciding, I mean, it's not for us to decide, but in formulating whether or not it was a unanimous agreement and whether that initially agreed to implement the remedial action. In the documents that were provided to us at the 11th hour, there's a cover letter which the chairperson sent to the public protector, where she says, this is the cover letter, this is our implementation plan, but I don't actually see the actual letter. So I don't know if I didn't find it in the documents, but there's a letter which was submitted to the public protector. So I think that letter will be important because it will tell us whether or which remedial action they didn't agree with or whether they agreed with all of them. And this was on the 22nd of August. 2014. Yeah. Yes.
Yeah, it is. Because so that you all know what we're talking about. And it's not a trend to us we can't reach agreement. As long as there's consensus on what it is, you don't think about it as well.
Cool.
Okay.
I'm not sure if it belongs here, but I think we need to mention the role of the minister in this entire. No problem.
We then agree that in terms of 11.1.2, members will try and go and recraft it for us. We'll also try from our side to try and recraft it, to try and indicate that there was a report that says you must do X, there was discussion in the board, ultimately the decisions were not implemented in full. That's the narrative that we want to relay. Okay, 1113. And we'll come back to your point, Mr. Mokoena, about additions. Anything on 1113? Oh, sorry, 1113.
It's just the reference should be to the subcommittee, a human resource subcommittee of the board.
Anything else on 1113? 1114? Eleven on 5. Okay, can I make a suggestion? 1115, of course, the very first line, unbeknown, I mean, that's grammar, you can sort it out. It's a Greek word. Appointed, between appointed and to provide, can't we say appointed a law firm? Because appointed to provide, so we'll just add appointed a law firm. You got that, Cindy? Yeah, we could say appointed Mkunu attorneys or whoever it was. Instead of a law firm, we can say appointed, yeah. Okay, you still, yeah, you'll introduce the end if you want to, but yours and then, I mean, Killian and then Loliwe.
Chairperson, I agree with you that we just delete the to provide, appointed a legal firm or a law firm to draft an opinion on the report, full stop, and just delete the last 3 words. So sorry. Appointed a law firm to draft an opinion on the report, full stop.
Loliwe?
Covered, Chair, because I was going to allude to the last 3 words, which did not make sense.
And then Honorable Mokoena wanted to suggest an addition to that paragraph. You were proposing some addition.
Yeah, I think it's a new paragraph, and it must speak to the role of the minister specific on her oversight on the implementation of the public protector's remedial action. Because one, she said that she was behind the opinion that it must be implemented. That's one. 2, she then went and suggested that the COO must be appointed permanently. 3, she went to a meeting at which the COO was appointed when the public protector's report was still in process. So she completely undermined the public, and that speaks directly to her office to uphold the Constitution and all of those things. I think we must mention that here as a separate, because I think her oversight is going to be extremely, extremely crucial in this thing.
Proposed addition. The sentiment and the wording, we will wordsmith it if the sentiment is accepted. Sentiment accepted, that there must be something said about the role of the minister in this matter. Will we be able to draft that? We will attempt to put something together. Thank you very much. That takes us to 11-1. Any points on 11-1? Mr. Swartz.
Chair, there's a lot of detail here about the disciplinary action and the appointment, the evidence file. Now, there is also other evidence about the changing of the initiator the day before the hearing was to commence, which severely impacted his preparation in the case, and that's in court papers as well. How much detail does one need to insert here? You see, we say the evidence file was never collected, the outcome. Yeah. The members of the disciplinary, yeah, that's no, sorry, I read that to be the panel sit-in, not the initiators, but that's fine, we can leave it, I don't want to waste time, but there's a significant item that has come out in that auditor's report that change, there's an irregular expenditure of 700,000 rand that was highlighted in that, but we don't have to go there at this stage, Chair.
Remember, honourable members, that all this relates or was processed through the Public Protector's report, and one of our recommendations, if adopted, says that Public Protector's report must be implemented in full. So we don't have to go and regurgitate what the Public Protector's findings were, I would have imagined. We're just saying these are one of the two things. It was not implemented in full, go and implement it in full. I'm sure that would suffice. If they comply with that, all the concerns we're talking about should then be addressed via the Public Protector's remedial action, I would imagine. But if members want to go and add more detail, you're more than welcome to do that. Once, going twice, going 3 times, 1112, ngiyayivala. Ayivali. 1112. Prof. 1112, close it, Baba. Yes. 1113. Huh? 1112. I beg your pardon. 1121. I beg your pardon. I'm sorry. 1121. I'm sorry, Mr. Honorable. 1121. Is there anything?
Chair, I wanted just to say, it says the Public Protector's report was not, a file was never collected or referred to during the proceedings. It doesn't say where, collected from where.
If you say never collected from the Public Protector.
Or from the Public Protector's office.
Oh yeah, that's what I'm saying. Would that suffice?
Okay.
That is what it was meant, that the Public Protector had something which they could have used and it was never collected.
So if it was not collected, there was no way they could refer to it because it would mean they wouldn't have seen it anyway.
No. Remember, this is also what the Public Protector was telling us. So whether they saw it or not, the Public Protector's report indicates that there was that document. And we had sight of the Public Protector's report. So whether they saw it or didn't see it or read it or didn't read it is neither here or there, but the Public Protector's report indicates that this has been done. All right. Yes, sir?
Is there sufficient evidence to justify the last sentence, the outcome and acquittal of all charges appeared to have been a foregone conclusion, even before the proceedings started? Yes. The key thing, because we are dealing with evidence here now, the Western Cape High Court said on paragraph 132 that there is insufficient evidence to find that the SABC board deliberately sabotaged the disciplinary inquiry. I'm just uncomfortable if there's a court decision on that we should say, reach that conclusion on the evidence that is before us. Maybe we just need to deliberate on that slightly.
I think it should come out because I don't think, remember here we're dealing with evidence provided. Neither the Public Protector or anybody came. This is probably after we had a little bit too much whiskey that we put that in there. Is it all right if we take out that sentence?
Yes.
There was whiskey involved?
I was having whiskey. Okay, we'll take out that sentence. Is that okay? Thank you. The last bit before we come to what everybody's waiting for, the observations and recommendations, because I'm sure that's what South Africa is waiting for. Can we do 12? We've got 5 minutes, but if we must extend it by extra 5 minutes, what I'm saying is we'll break after 12. All right.
Chair.
1, 2. Okay, sorry. No, Why are you shouting, Baba?
I didn't shout.
Oh, no. We'll accept you, and then you'll be number 2 sing. All right.
No, I was just wondering if, given that we're still going to make all these changes and, that if we shouldn't perhaps make those changes, look at them tomorrow, and then look at the recommendations.
That could be another approach. I'm saying that could be another, but let's discuss that once we finish with 12. Okay. 12.1, any comments? Honorable Singh.
Yeah, Chair, thank you very much. Before we go on to 12, evaluating testimony, I would think that there is some testimony which is important that might have been omitted and which will impact on our recommendations and what's happening outside of this process. And one of them relates to the assertion that there was political interference and the other that there was no political interference. You remember when we heard from the last 2 people? One said there was, the other said there was not. And I know there are some court challenges that we've read about. I think we've got to make some reference to that testimony which was made before this committee. And related to that was a testimony by one of the board members that a certain Lulama Patricia Mokobo was related to the then minister, and it is because of that relation that she was appointed. Now, she's given us an affidavit in this document, all these documents here, that she categorically denies that she was related. Now, I think evidence or testimony like that needs to be included, as part of testimony so that we can make a recommendation or finding, because I recall you very clearly saying, Chair, we're going to find out who is lying. Somebody is misleading this committee. And we can only do that by placing that evidence in front of us here and then make a finding on it. So those 2 areas, the political interference from 2 people or not, and then because it boils down to the credibility of the witnesses under oath. So I'll just stop there, Chair.
Okay, but then, and of course, as we said this morning, we're not going to be flexible. Shouldn't we then have a heading that says, as you say, contradictory evidence? We'll then have to pull out what we said earlier on the full story, because more than anything else, one said that the breakfast cost something, the other one said the breakfast cost absolutely nothing. So we could have a heading that says, these are 3 glaring examples of contradictions. And if there are others, you'll put them in there. So what I'm suggesting is, should we have that as a heading? Because I know that there's some recommendations to that effect that were being proposed. So we could have a standalone heading and use those 3 as standalones if you are saying we must put them out into the public. I'm proposing that where we have evaluation of testimony, we then can put contradictions and other or whatever we want to put. We can just put the headings. But let me take you and the Loliwe in terms of how do we package it.
But Chair, what I'm suggesting is before we even evaluate, we've got to put the testimony. We've got to include the testimony that was led, and then we can evaluate.
Right. So somebody is saying something that's glaring there in this thing before we even get to the evaluation is the credibility of witnesses. Oh, no, yeah, we'll just put credibility of proceedings, and we use examples. So, and that will be before evaluation of testimony.
Actually, Chair, what I'm suggesting, it comes as testimony, not a heading credibility of witnesses. It comes as testimony. That issue on the political interference, etc., comes as testimony. The committee also heard that there was and there was not, etc., etc. And then under evaluation, we can talk about credibility of witnesses.
We're agreeing, but we're saying we've tried to put it under headings, all these things, whether it's discipline or whatever. What we're trying to ascertain is, should we have a heading and then use those 3 examples? And I was suggesting the heading should be contradictions or whatever you want to call it, or conflicting evidence. Contradictory evidence, conflicting evidence. I know, but I'm saying before we get there, what is the heading, Baba? Contradictory.
before. Before we,
Yes, no, we're saying it's going to be before evaluation of testimony. We're going to put a heading that says contradictory evidence. If when we get up tomorrow we think conflicting evidence sounds better or whatever, we'll change it. But for now, we're going to put contradictory evidence. And all I'm asking is, can members suggest what examples do we put under that heading, whatever we call it at the end of the day? We've agreed that we're going to put evidence around, for time, let me just give those that we know. We're going to put evidence around Ben Gubane said there is no cost to the SABC. Vuyo Mvoko said there's a cost to SABC. That's the first one. The second one is that Ellen Shabalala said there was gross political interference. Ben Gubane said there is no political interference. Those are two. Any other ones that you guys want to put there? Okay, there was the one about the family relationship that Ben Gubane said the appointment of Dudu. No, it was Ben Gubane. Ben Gubane said that the appointment of Duda somehow was linked to the fact that she was related to Minister Pule. We've got an affidavit from Duda saying there's no such thing. Those are three. All right, let's start there. We're just talking about those using as examples. Let's start here then. 1, 2, 3, 4, 5, 6. We'll go in that order. Baba.
No,
and you must argue your case. We'll reject it. If
the fourth one, Chair, is the contradiction around the issue of the selling of archives. You'll remember that when we deal with the multi-choice, and the point that the minister made was that that information, meaning that the archive is not sold. And when we're dealing with, was it Shushu? The fact was that that archive, or Masinga, was that that archive is being sort of sold. So I think that's one area that we'll definitely have to deal with clarity on that particular area. Yes, it is.
Further contradictions. Dr. Ngubane disputed that he said that there was a board resolution saying Mr. Motsoeneng, there was a board resolution that Mr. Motsoeneng could come to the board meetings because he'd be the spokesperson of the committee, of the board or something like that. That is disputed because others say he was brought by Dr. Ngubane. I've got a letter here. I think it was Phil Masing, yeah. No, not one.
No, that is a hearsay.
No, it was, yeah, Mr. Masinga who said suddenly there was Hlaudi in all the meetings. And Dr. Ngubane insisted that there was a board resolution.
You'll just get the sources for
We'll
that
get the
overnight.
sources, yeah. And then the second one was the contradiction about going to Pretoria. Dr. Ngubane said that conversation didn't happen. Mr. Molefe says that conversation did happen. Another contradiction was about the TNA breakfasts. No, who came up with the idea? Mr. Molefe said it came from the COO. Dr. Ngubane said it came from Phil Molefe. And any other ones? I had another one which I've not forgotten. Sorry.
Chair, the issue about the MOIs, the minister had signed 2 different MOIs, and she came here and denied that she'd signed either of them. So I think that needs to be stated. The other one about Dr. Ngubane, the minister signed MOIs. 2. Yeah, we've got copies. She denied she signed it. So that's a contradiction. Okay, and the other one is Dr. Ngubane, where he said the board took a decision to give the COO the 62% increase. If I remember correctly, it was just him unilaterally that signed the increase. Yeah. Okay. Yes. Thank you. That's those two. Thanks.
And then Dr. Ngubane also said that there was it was a board decision to appoint the acting CEO, acting COO. No, there was no other evidence to prove that. Everybody else said that it was his decision. That's what I'm saying. You're saying there are those that say it was what's his name? Naidu. Naidu said there was no board decision around. The what?
The appointment of which position?
Of acting COO. Yeah. So, yeah, Ben Ngubane said it was a board decision, and he said that he would provide the minutes. Yeah, you must tell us if we received the minutes there. And then to the issue of minutes themselves, because we received 2 different versions of minutes. Yeah.
The minutes, yeah, the differences or variances in the minutes. Okay, we'll list all these things because we are just listing them for now so that people here mustn't think we're taking a decision on them. We're listing them. We'll have a process of verifying them before we adopt them on the 24th. Please report accordingly. We are not for 1 minute saying that these are. We're saying we are listing them as we understand them. We will verify them, and by the 24th, those that are genuine contradictions will remain. Those that are not will fall off the list. So that is clear understanding on that one. Honorable Swartz. We'll come around the back if there are any. Swartz.
It might just be more a difference of opinion when Dr. Ngubane sang the praises of Mr. Motsoeneng when many other witnesses held a different view. I don't know if that's a contradiction or more a matter of opinion.
That's a matter of opinion. Don't even put it there.
The other issue related to the evidence by the minister relating to the multi-choice agreement, where she indicated the matter was cleared by ICASA, the regulator, etc., and there seemed to be other evidence that there was great concern from Mr. Krishnaidu about that whole multi-choice agreement. So it could also be seen as a contradiction, Chair. But we can look into that.
List all of them. Some of them might be covered in other recommendations, others not. But we'll list all of them and we'll go through them one by one by the time we finish here tomorrow. Honorable Mahlangu, and we'll go around the back and then we'll come back to you, Van Dam. Honorable Mahlangu, are there any things you want to add?
Well, I guess quite a lot of things have been covered. The issue, the 63 that you are referring to 500,000, I assume, isn't it? When colleagues refer to the 63%, they are referring to the 500,000 that Phil said.
It was 63% salary.
Yes, that's what I'm. Okay, there's a 500,000 matter that, and I can't remember what it refers to, where I think Phil said the doctor was given a letter to sign, and the doctor said no, it is an HR process that came, and then there was a board decision. I'm not sure whether we're referring to the same matter. There's an issue of going to India, which I think had different opinions. Dr. Ngubane says Phil went to India, and in Germany, I think, to speak to...
India, to a company, yeah.
Yes. But on the other side, there is and I'm just not clear as to, but I know that in other evidence there was information to the effect that that was actually generated by either the CEO, because the India visit, according to Ben, although he said India, but he can't say, but he knows that the company that eventually came was sourced by Phil from India, and Phil had said that initiative was I think we'll have to check that aspect because I don't want to misrepresent. But I know that he said something else, not what we got from former chairman. I guess the rest of the other things that colleagues have raised are the things that I've spoken to. And agreeing with the last sentiment here on page 25 with regards to the difference between the minutes. And I don't know how, and I think the chair...
Sorry, what are you saying? Which one are we?
The minutes, the one that are appearing on page 25 on top, 26, 12A. This information will obviously form part of the contradictions.
12.4.
12.4, yes.
You think it must go to part of this list that we are making?
Correct. Because it's contradictions in minutes.
Okay, that's fine. We'll take it out of there and we'll just put it in the chapter above. That's your proposal. Prof, could we say anything?
Yeah, on the issue of the visit of Mlifa to India, yeah, that one is a very serious contradiction because it was like Dr. Ngubane was saying, was distancing himself from that initiative. But according to Phil, it was like it was an SABC decision. But Dr. Ngubane seemed to distance himself from everything that Mlifa was doing.
Honorable Koza?
Thank you,
Additions?
Chair. You've even forgotten my name because I was quiet. Get used to it. I can be quiet, Chair. Chair. No, Chair, I wanted to say one of the things we'll have to ask the staff to do for us is to really zoom into the testimonials of both Ngubane and Molefe, because there were a lot of contradictions. In fact, both of them were on the opposing ends. So I think without wasting time, we needed to actually zoom into that. But I thought the other fundamental one was on the actual appointment of Motsoeneng. I recall Ngubane saying that was on the recommendation of the CEO. It's not that he invited Motsoeneng himself to just sit there and suddenly he's the one that was instrumental. But whatever that he did, he appears to be suggesting that it was as per the recommendation from the CEO. And that is very important because, yeah, I think that is going to be absolutely important. And Chair, the issue around the records is also going to be absolutely critical. Remember that the minutes, I know that Advocate Navarra, Vanara, okay. Advocate Vanara had already extracted that. But I do think that we need to point out these anomalies. It's not enough to simply say, you know, there seem to be discrepancies. We have to point out what exactly are those discrepancies in the minutes, because that can easily be disputed in the evaluation of testimony, Chair. I think that's very important. Thank you.
I'm covered, Chair, thanks.
Chairperson, I would have suggested that Mr. Vanara also supports us in identifying those issues, those statements where there were contradictions. It is important for him as evidence leader, who have in fact also assisted the committee to extract information from the different people, to indicate in which respects he believes that very serious contradictions were brought. We have an exhaustive list, but if there's anything that was omitted, if he could support us and help us with adding to the list. Thank you.
With the very last one, Honorable Van Dam, on this point, and we're moving on.
Thanks, Chair. Major contradiction. The Minister of Communications, she knew nothing, she saw nothing, she didn't ever interfere with the SABC at all. And there's plenty of witnesses who said she did interfere. So can we include that contradiction?
Will you assist us with identifying those kind of witnesses? We'll do that. Because remember, we're going to go through a process of elimination. This is a wish list that we've been throwing there. We'll argue them tomorrow or later tonight, and those that we don't think are defensible will be removed. So when you throw a suggestion, be able to substantiate it for tomorrow. But let's take Mokoena and Mahlangu will be the absolute last one.
No, Chair, just on clarity. The issue of going to India and who initiated the New Age deal are one and the same. Because what Benu Ngubane said was that Phil Molefe initiated the New Age deal. He's the one that spoke to the Guptas and everything. And they then had 16 shows that he was not involved in. He then said, subsequent to that, then Phil Molefe went to India to go and conclude other business around the New Age media thing. And then he came back and presented a business plan to the board. That was his version. Whereas Phil said it's the COO that called him and said, we must do this thing. And then Benu Ngubane was sort of in there, yeah, sure.
All right, Mahlangu?
Chair, the other matter has to do with the commercially sensitive matters. And from different witnesses, I think it was clear that, even one of them, the minister said it's not commercially sensitive because it was presented to the committee, but there were those Maguve and company who said, even in their affidavit, that these things will not be released because they're commercially sensitive. And I think your Multichoice is one of them, and a host of others. I think they are there. We've got them in the list there, especially the things that we had subpoenaed them for.
Yeah. On that point, that advice was given by some attorney. Remember, it was written on the letter of the attorney. So it's not just the company secretary and Maguve on whose behalf it was written, but the very attorney on whose letterhead it was is complicit. But we'll through process of elimination tomorrow, some will remain and some will fall off. The very last point before we get to recommendations, and we're running 15 minutes late, and you're not going to leave Mokoena because we agreed we're going to finish this thing sonke. We took that decision, Baba, that we'll finish it together. Otherwise, if you leave, other people will leave and we won't have a quorum. Is there any matter that members want to raise other than grammatical on 12.1? Honorable Swartz.
Chair, the evaluation of, are we replacing that now? We've changed the heading, or the whole section of what we've dealt with, the contradictions, is a separate section. Now we're dealing with evaluation. Firstly, it's evaluation of evidence. That is a complex issue. It's not in one line. And I would ask the legal advisors to look at that. How? Because they would have led evidence advocate for NARA. We are not a court. We're not subjecting people to cross-examination that we reach a conclusion of what evidence we can accept on the basis of cross-examination. So I'm not objecting to that statement, but by merely putting that statement, there was corroboration in a majority. I would say in most of the testimony, you've got to then say, but what? What do you mean by that?
Let me help there. And again, what I'm saying is, this was probably what we were putting as evaluation, but I just have a quick glance of them. All of them, in essence, almost fit into the category that we were discussing now. I'm saying, let's leave the heading out for want of a better word. If you go to the corroboration of major testimony, witnesses, that will fall out because it was just a heading. But if you go to 12.2, it talks about the MOI, which we covered. There were 3, there were 2, there were 1. the infringement of or the role of the minister where she denied. I'm sure all those would fit in that category that we've
think
just
so.
discussed now.
That's better than take out, we're not evaluating the
No, that's
evidence
right,
at this
yes.
stage. Yeah.
So
No,
we'll take out that heading evaluation and whatever many those are there. Can we just go through these from 12.2 to see if they still fit those or do they come out? 12.2, so forget about the heading. Does 12.2 stand the test of time from our side? Any comment on 12.2? 12.3? No, I beg your pardon. Yeah, that should be 12.3 because we've got 12.2 twice. The second 12.2. Any comment? 12.2. The second one, yes. Mr. Mokoena and then Mr. Mokoena.
Chair, I have a feeling that what we've just discussed covers this entire topic.
Yeah.
So can we just relook at the entire thing?
We're saying we're just going through them and delete them if necessary. Or must we say we must just add it and when we look at others, we look at this one? Is that what you're saying?
Yeah, let's just redo it.
Okay. No, that's fine. All right. So what we are saying, because remember point 12 is a matter that we're saying we will revisit in detail. When I say point 12, the previous heading, we'll revisit in detail and eliminate them as we go through. We are going to add these to them, and in that process of elimination, they'll either fall out or stand in. Okay, Cindy. All right. That then, honorable members, takes us to the end of the body, which is 26 of 36 pages. So we've gone 2/3 of the way. We're just left with recommendations and observations. There was a suggestion, I'll come to you, Mr. Mokoena. There was a suggestion because recommendations and observations are based on what we've done for the whole day today. That we try and find a way of trying to capture, at least so that we are all of one mind from page 1 to page 27, or 26, before we carry on to the 27s to 37s as they stand here now. That was the one proposal. The other proposal is that we can continue with those things out of memory. I suppose those are the two practical realities. And you are 20 minutes late for your supper. I can see you guys wanting to get out of a late night. But remember, honorable members, what we lose today, we're going to make up tomorrow. We're going to make that up tomorrow. So which proposal are we going with? Or what is the process? Because we agreed on a process. Let's take Waters and then take, how do we go forward?
Chair, my
1, 2, and 3.
My suggestion is that we carry on after supper as far as possible. We must set a time, and when we reach that particular time, that's when we go home. My fear is, Chair, if we go with the first proposal, I mean, the staff have to capture everything. There's a lot of changes that have to happen from the beginning of the document, right? As well as members with their proposed amendments, but there's a lot of work that has to be done from the staff, and I don't think it's reasonable to, well, they're going to have to work through the night if we want the document ready for us in the morning. And so for me, I would rather we carry on tonight and do as much as possible. And then make a decision whether or not we actually meet on Friday or we meet next week to carry on. Because there's no point in expecting the staff to rush again and then forcing them to make mistakes. I mean, this document, as we all said, there's quite a lot of spelling and grammar issues, and I think we should do a proper job. So for me, we carry on tonight and see how far we get.
All that we're left with now is to deal with the observations and the recommendations. That's where we are in the process. The question we're asking is how do we take it forward from here? We've got a proposal from Honorable Waters that says, let's go and have a break and see what we can do with what is here. Honorable Mokoena was saying, no, but let us first go and clean it up and come back. So let's start by you, sir, and we'll go up this way. We'll leave these two that have already spoken, and we'll end with you, sir. How do we take this process forward? You've got 1 minute, Baba.
No, Chair, my proposal is going to be informed by the capacity of the committee to be able to. Oh, it's finished this one. Okay, thank you, Chair. My proposal, in fact, will be informed by the capacity of the committee to be able to package all the work that we've started in the morning at 10 o'clock till now, which is very, very critical work. Therefore, I'm going to propose, Chair, with respect, and I respect the point that the colleagues have made this point that, you know, we don't have much work anymore, that we adjourn now, we convene tomorrow earlier than 10 o'clock. We can convene tomorrow at 8 o'clock. Then we know that we can push until 12 o'clock. Definitely will be done by that time, Chair.
Thank you, Chair. I would support Honourable Chauke that we adjourn and that we reconvene tomorrow morning when all of us have at least consumed some of the stuff that we've parked under observations, etc., because we cannot go to the recommendations without also listing in our own minds the observations. The recommendations flow from the observations. So I would suggest that we rather reconvene tomorrow morning.
Yeah, Chairperson, I find a bit of a contradiction in what Honourable Waters is saying. First he's saying we should give the staff time, then he says we should meet after dinner. So when do they get the time to put together everything that we've spoken about? What I want to suggest is another proposal, Chair, that we have dinner, we come back, and let's just talk broadly about the next section in terms of how it should be structured, the observations and recommendations. You know, so that they also apply their minds, our support team, because there are certainly things that, you know, one would like to talk about in terms of the headings and some omissions in the recommendations and observations, which we don't have to discuss in detail, but just mention them, and then the committee can then apply their minds. Thank you.
Thanks, Chair. Chair, I'm thinking of if, for instance, we say we break now and allow the staff to consolidate what we've been doing. One of the things which is influencing us to stop now is fatigue, if we are honest. And it will be the same position with the staff members. Where I'm seated, I would say, even if we adjourn now, we must not expect staff to come with polished work tomorrow because they are also tired. Let's target what you proposed, that the best issue would be the document of the 24th. So I agree we can adjourn, but let us not say let there be some group that is continuing with the work because they are also tired. Thanks, Chair. So we adjourn now and then we start early tomorrow. But for me, 8 o'clock may be impossible. Let's rather say 9 o'clock. I'm saying impossible because there are people who have transport coordinated centrally. Communication has gone to the company already on the pickup time. So rather than ambushing them to say they must pick people up at 7 versus the 8:30, let us rather say they must pick people at 7:45 so that they are here by 9 o'clock. Thank you.
Thanks, Chair. I would like to suggest that we continue. I'm hearing the suggestion that we set time tomorrow from 9 until 12 it was. That's what, 4 hours, 3 hours. The recommendations and the observations is the nub of the work that we're doing. 3 hours of, how many is it? Sorry, my math's not great. The amount of hours will not be enough. I think that's where we're going to spend. There'll be a lot of discussion, there'll be a lot of debates, and we must not limit ourselves in terms of time and rush it. So I'd say let's continue, finish it, and if we're not done, we come back tomorrow morning and we finish the recommendations. And then that gives the staff enough time to look at this over the weekend, look at it on Monday, and present us with the report on the 24th. We must continue.
But he's
I think we
spoken.
carry on, because...
He's spoken, Chair.
Carry on.
Spoken. Have a second bite.
No, Chair, look, the idea of, I think the concept of having a polished document is impossible at this point in time. And I think the fact that, you know, we're all going to continue working, leaving here. The staff is going to work, we have inserts to make and so on and so forth. So everybody is going to work. So let's go, let's work and come back with an idea of what the document is going to look like. And that is going to inform us. But I agree with Honorable Van Dam that this is the most important part of this document. And we can't do it at the levels of fatigue that we're at now. And with the less information that we have in the document that we have as it is. So I'm advocating that we must, immediately after dinner, that we go home and sleep. Thanks.
Chair, we've got a lot of work to do still, Chair. We've volunteered, and I think some of us are forgetting the amount of work we've got to do. For example, to go through that whole auditor's report of 250 pages, that's going to take a few hours. So there's work to be done. And I don't think that, and we are fatigued already. I suggest that we have dinner and we adjourn, we start again tomorrow morning. We go as far as we can. It's not final, because this report is interim. It's an interim report, awaiting further input. So that's my view.
Chair, my take is that we start tomorrow at 9 o'clock. Yeah, we're Chair.
Well, Chair, I will have to live with the majority suggestion, although you'd remember that I was given an assignment to come up with a problem statement. And the reason why I was out of action for the bigger part of the day is because I was working on that document. So are you saying the problem statement, you get it tomorrow, or you want me to give it now at closure, because that was the original decision? I've got it ready.
Ask the question, let's answer it first, and then we'll come back to it. What we are saying to you is that if those that ask for us to carry on after dinner are the majority, then you're going to have to give it to us because you have it ready. If those that have suggested we go and work independently, when I say independently, the group that is going to do chapter 1, the group that's going to do chapter 2, the group that's going to fix up whatever, if that group, I mean, if those that say let's go home are the majority, then we're going to go and work separately. And being the fair adjudicator that I am, the results are as follows. Those that propose that we come back after dinner to continue are 3. Those that said we should go home and come back at 9 o'clock are 8. So the 8 win.
Sorry, Chair, point of order. I'm not allowed to vote. So.
You're not going to allow that. All right. Your dinner is, or you've been half an hour late, but there's dinner where you had lunch this afternoon. Can we just get an indication before you go, Cindy? Has anybody taken a register of who needs to do what? Have you? You want to just remind us? We took a decision earlier on, Mr. Swartz, that we are going to come back with our own input. That stands. Whether you do it between now and midnight is your problem. Members still, to Do members still remember what they made undertakings to do? We have. If we have, when we reconvene at 9, you're going to give us something so that if it means that we must reproduce it and give it to members, we'll do it because we're going to debate those type of things. So please, could you make a point that at 8:45 we convene here, those that have got some documents, we'll take them from you, we will make enough copies for everybody so that that is there when we carry on. Is that fair? Now, I know that there are groups that are going to do it, whether it's telephonic or not, but what we're saying is between now and 8:45, all those that volunteer to assist in either crafting new or strengthening what we have, you've got until 8:45 to, well, your absolute latest to give us is 8:45, as far as is humanly possible. Of course, others might be a bit more difficult, but can we attempt that to the extent that we are complete, can we have it at 8:45 so that we could reproduce and give to members? Is that fair enough? Thank you very much, Honorable Van Dam.
Thanks, Chair. Okay, fine. We'll come tomorrow morning. Can I just be clear about where we're going to start and the fact that we shouldn't put an end time, because we should just exhaust this until we've decided on the recommendations.
I indicated because, like I said, some of us are migrant workers. We try to push, but we're not going to do things for doing its sake. So we will start tomorrow by receiving those presentations and at least agreeing that it's a fair representation, because that has to be the basis that we would use for our recommendations. So if you do a terrible job, we'll have terrible observations and recommendations. So where we will start is to receive, both from us here and yourselves, the amended report as it is. We will grant through them quickly to make sure it is what we have expected, and do very much as we did with the others. And hopefully, we'll get to there. And hopefully we'll set a time aside, depending how many there are, I don't remember now. Let's say the first 2 hours will be to discuss that. And then we would break for lunch, or not for lunch, for tea. From tea onwards, we will carry on with recommendations, observations and recommendations. And when we leave here on Friday night, we will have a sense of a 90% document. Because remember, then we still have to go back ourselves and work over the weekend, give it to you on Monday, so that on Tuesday we continue with this process. So let's be fair to everybody. You can't expect to do this thing, give it to us, and then expect us to give it back to you so that you can have a constructive discussion on Tuesday, unless all of us have sufficient time. Some of our weekends, our weekends are non-existent. So, once again, Ma'am Van Dam and everybody else, 8:45, all the scribes will be here to give us. From 9 o'clock, we will process those that we have, because it's only those that are outstanding. Everything else we've agreed upon. We'll process those, and we'll process the last chapter that we've had in terms of, is it really a contradiction or not? So we have those to do. Hopefully we'll do that in the next 2 hours or whatever time. Once we've dealt with that, we then get into the observations, because if we agree on the observations, it's not difficult to reach the recommendations. So we'll do observations, conclude observations, do recommendations, conclude recommendations. We will go back and try and reproduce a document that emanates from our discussion, and hopefully Tuesday after 2 o'clock, Ms. Van Dam, will be able to, all of us, sit and adopt a draft report that will go out for consumption. So that's the process, roughly, honourable members. Are we comfortable with that? Of course, we'll be flexible if there's something that is outside of our control, but that is how we're going to proceed from tomorrow. There is dinner being prepared now, and then, honourable members, Cindy is indicating to me that you've got two choices. You either bring a piece of paper here at 9, or otherwise you email her your proposal and she will try and reproduce it for us. So in other words, if there's a proposal, if you send it to Cindy, she'll find a way of reproducing your one, whichever one it is, and then we'll be able to have documents. So it's your call. You either send it to Cindy by time, Cindy? This evening, by 8. If you send it to Cindy by 8 o'clock tomorrow morning, then you don't have to come here at 9. If you don't send it to Cindy by 8 o'clock tomorrow morning, you must come with a hard copy here at 9. Here's one. Let's go and have supper.